governed by the power.
We moved the ones on that side forward and taken them down there. We could roll the rest of it. I think so, we can. There's a cable thing in that corner. Well, right, I'm going to need a laptop to open this up. Yeah, it says rude. You could have, there's a bit of sit there, there's no leg room.
Yeah, not too bad. Yes, yeah. It's good and bad.
They're all taken all.
It's good that it works, but bad that you don't get as much. Yeah, yeah.
I've got an extension cable. Does this help? I'm going to need one of them, so we can pull.
Right.
So if you've got 2 or 3 more, let me just find them for you.
Yeah, there's power under here.
Yeah, you can put it down.
Yeah.
Right.
I was going to say, is that how you guys have arranged it?
Yeah, well, actually we had 90 last week. We're improving guest Wi-Fi on Monday. You just need to register. Oh, that's perfect timing. Almost as if we planned it.
Yeah. Well, although, is it the pessimist in me that says maybe you don't want the very first day to be a test bed for an examination, but maybe that is just the pessimist.
No,
So, I had got an extension cable for them, but I'm not bought it. We use extension cable. Put it on a spare chair.
Do you want to pop it?
Yeah, stick it in and you can...
Yeah, good, yeah. So, what do you need? Any hand at all?
Joy this for me. Although I don't think that car park's going to be a joy when I end up paying it. I'm going to end up, I think I'm going to end up listening to Maxine tomorrow.
Yeah.
Probably
Cheaper than I think it was last night. Keep on going, because they're not going to
They are right. Thank you.
Well, I think there are a couple of questions after we'll be just
Yeah. Yeah.
So the chat services.
So you're not using guest Wi-Fi?
Yeah.
Tried all the network cable points.
Yeah, okay, let's
No.
Maybe try that afterwards.
Yeah.
Tomorrow or something. There might be one line.
Is it coming?
It's the thing with having all your laptops and things on it.
Further back. Move down the other side of the device.
Yeah.
Yeah, do we need to all spread out a bit? We could all spread out a bit. If everyone moves down, I know everyone's set up, if everyone moves down a bit, we're going to have a bit more, potentially a bit more space and put a few papers.
Yeah, we'll
I was
wing
just
it.
saying, look, if we move away a bit. Yeah, and then we've got a bit more space for papers. We've got plenty of. We have to send it tomorrow if you want more people.
I think you're next to, I think you're up here. Yeah. I think it's up at the table now.
They let me in eventually after asking lots of people.
Oh, did you go around the side?
I went around the side, but yeah.
Oh, right, yeah.
Yeah.
Actually, just happened to come across open doors as you walked in.
Otherwise, I've got no.
Posters out. But there's some at the front, at the front doors that you see that as you walk past.
Yeah.
All right.
You're right. All right. Morning, you all right? Sleeping well?
Yeah, you.
Yeah, not too bad, not too bad.
Yeah.
I missed all the fun and delights last week.
I know. Warrington.
Warrington.
Yeah.
That'll be a warm one, though, isn't it?
Oh, no, yeah. I decided to discard the jacket. I thought I'm not going to. I thought this is going to put it sit on the back of it.
Depending what your aircon is, that's what you need.
Yeah.
Suppose we all sort of sneak out and.
It's the council, they're not going to have it. Put right. I need a plastic.
Oh, did I? Sorry, Simon, did I not do you?
my mind.
Oh, good, mate. How are you?
You're upside down. Yeah, we haven't met Sarah actually.
No, tell no. No, I registered, but he gave me a code, and now let me use my name again. To be honest, I took my stuff out. You're not catching me out. I've been here before, mate.
We give you your username.
So what was the random instructions?
Okay,
So
the guest needs to create a guest username and then enter first name, last name, email address, and company. Once you've registered, you will get an automatically generated password.
Where do you get the passwords from?
Yeah, it doesn't. It will send you one when you go into the registration.
Well, you would get an email if you're that simple.
So what do you do for it?
This is what we're trying to learn now. It's a very good question.
Mine just came up on the screen when I did the registration.
What's the
What's the list?
Not that.
Yeah, so, but I haven't got
Email, and if you've got that number behind it, I want you to register and check my service in that sense.
Yeah, yeah. No, that's what I've gone into. It's just
but there's no
like,
registration.
No, but is it not?
Ah, there we go.
Is it not going to sort of almost
Am
like
I in the
force
wrong?
register?
Is it some in the wrong?
Unsecured network.
It's 1893. That's the one. Oh right, so that's the one.
log in, username? Please sign in for guest access or register. Do you just create it?
Right.
Not this side. There's not many on that side anymore.
Create guest username.
What do you put in for your user? Just make it let anything else?
Automatically generated password. So the username should be my email today.
I'm going to put my email address in. It's early, isn't it?
We probably need to take that down so you don't make yourself confused everywhere.
Authentication failed.
welcome to my world.
I agree to the terms and conditions. Why is it made so difficult?
Thank you.
How are you getting on, Andy?
Yeah.
Well, I mean,
Just says authentication failed. Or, please sign in for guest access. Or register for guest access. Right, let's go again.
No.
Sign in.
I don't think it has.
Authentication failed. It's not working. I've registered. No, it's still sad.
Sorry, do you happen to know if there are any other sort of servers that could be used? Do you happen to know if there are any other servers that could be used?
So I've got.
that's what I'm aware of. So have you tried the 1893 one? Is that what you're
That's what I'm trying to get on, and I've registered. It says I've got the Wi-Fi.
That's right, so if you expand those details, and,
Yeah.
so that's really
Oh, password is one. Why did I put in a different password? Yeah, sorry, because it says when you register, it asks you for a password. So I put a password. So I put that one on. That's a bit weird. Yeah. Right. So will that work if I put it on here as well?
It should do, yes.
Right. Do you actually do this every day?
Every 8 hours.
What?
But you have to, don't create anything.
Landscape. Anyway, the master expedition, which they got, but obviously the master expedition ages ago.
Yeah.
And the court's finally looked at it and expedited it, but court term finishes on the 31st of July. So that means some paper issue where you're actually made. That would be
Right.
so nobody actually wants it expedited now, so it's too expedited. But now the court's refusing to shift and have it October. Anyway, it's not too bad because firstly I've got a team of people who are doing it, working on it, and secondly we're feeling this has happened there, what we did a really detailed preliminary separate paper, so we are just adding a few extra bits to that. But the Secretary of State's instructed someone, myself, brand new on it. I think what's the terms around a couple of days. That obviously preparing for this as well. So yeah, I don't know what time I've got spent.
No internet.
It does send it to your email, but you've got to have your email.
Yeah, you have your email to actually get on. It doesn't help when even my iPad here doesn't connect to it automatically. It clearly thinks it's a bit dodgy.
Yeah, I think we've got that in the end.
We're allowed access to the world.
outside scary now, isn't it?
This what's over one.
It's matter one.
Yeah,
around it.
yeah.
And then tomorrow it's housing, but there's new part of it on
Yeah,
covering
yeah,
that.
it's got a new mix.
Yeah.
Yeah. The second.
The second. Right, well that's why we've got people down there. Oh good, there are people there.
We just came up and we were just looking at
It's also not open until 9 o'clock. Another reason Well that might be why people are
So we should come in there.
yeah, as long as
All the staff downstairs
there's
know
people off
that it's on and
yeah,
all
yeah.
the reception staff know. So people bring it to.
I think actually might like this stood on the door. Okay, yeah. You did well to get that far. Yeah, so actually we've got they've just emailed. Just emailed at 11 minutes past 9 saying, see you at the hearing later today. In 19 minutes. Oh, amazing. Thank you. Maybe they're coming for later.
Yeah, maybe. Which would take.
Ian, answer to your question.
Yeah.
It's more about who's. Oh, right. Let's just take a step outside for a minute. I tend just to try and manage without them until it starts feeling quick, because, as you say, otherwise it's because it's on and off all the time, and then half the time I put myself in, I can't see anything.
Yeah.
Oh, look, there's the information on there. Someone just written that up. That's the lifetime writing.
I think that was there. I think that was good.
Well, that knows that.
I'll ask Amy. I'm trapped. That's Daily. Yeah.
Morning. Hi. You alright? Hi.
Alright.
You okay? I am. I'm gonna sit down now. Right.
What's that? Well, I'm using stuff that I've downloaded on the computer.
Have you got onto the website, sorry? Yeah, mine's fine. Mine's fine.
When I said I know, I thought you were talking about me. Yeah. Okay. That's all right.
Tough of you.
Not because I live, just because she lives there.
Yeah.
Before we started on this occasion. People play that football match in Manchester. Chatting to one of the mums I worked out, she was actually doing my first yes, Katrina. You got me.
No escape.
Yeah.
Okay, good morning everyone and welcome to the first hearing session on the Sheffield Plan. Can I just check, can everyone hear me? Thank you. My name is Katie Child and with me are my colleagues David Troy and Rosie Morgan. We are all Chartered Town Planners and Planning Inspectors and we have been appointed jointly to conduct the examination of the Sheffield Plan by the Secretary of State under Section 20 of the Planning Act 2004. So the examination will be based on the draft version of the plan, which was published in January 23 and sets out the Council's strategy for development and growth between the years 22 and 2039. Our role is to examine the plan and to determine whether it's legally compliant and soundly based as set out in the National Planning Policy Framework. As part of this, we will be considering all the written evidence before us and the written representations, and we'll also be taking account of verbal submissions made at the hearings themselves. So the hearings are being held in 3 stages. The first stage, which is this week and next week, will be focusing on strategic matters, and then we resume with stage 2 at the end of September, when we'll be talking about specific sites then, and then moving on to development management policies after that. The full hearing programme can be viewed online along with agendas for each day for this week and next week. So the hearing session today is covering legal and procedural matters and the duty to cooperate. And today there will be the 3 inspectors at the table for most of the day as we're leading on different parts and there are cross-cutting issues to cover. But that will be an unusual occurrence, so most sessions there will just be 1 inspector present, occasionally 2. Depending on the agenda before us. So before we get to the main agenda for today, we've just got some general points to make about the examination process and how the hearing session will run. Firstly, I've just got a few practical points to run through, the usual practicalities. Because this is the first session, we also wanted to say a few words about the plan and the modifications process. So for that part, I'll hand over to my colleague David Troy. And then Rosie Morgan will finish by saying just a few words about the purpose and the format of the session today. So in terms of the practicalities, just a reminder that these sessions are being live streamed on the Council's website. So welcome to all those who happen to be watching this morning. Also to say that with us we have Ian Kemp at the back. No doubt all of you will probably have had some sort of contact with him. He's the programme officer for the examination, so he's responsible for all the admin arrangements. So if you have any practical issues or questions during the day, then please see Ian. Can I just check that everyone has a copy of the agenda? Yeah. Okay, thank you. A reminder as well to turn off mobile telephones or put them on silent. And just to say that if you are intending to film or record the session and share any images online or with others, please be aware that you will be responsible for complying with relevant data protection legislation. I also have a declaration of interest to make, well, for myself and also on behalf of David Troy. We are both alumni of Sheffield University, who are promoting a number of development sites in the plan. However, we both attended the university a very long time ago and have no contacts at the university. I won't say how many years because that would give our age away, but a long time ago. Therefore, we do not consider it would prejudice our examination of the plan or interfere with our openness, fairness and impartiality. Okay, I'll now turn to the Council, please, just to talk through any fire alarm arrangements or any practical matters. Thank you.
That's all right.
Thank you.
Right, thank you. We should have checked that, shouldn't we? Yes, just a couple of practicalities around the fire alarm. Please note that there will be a fire alarm test today at 11 a.m. It happens every Tuesday morning, but no action is required today. In the event of an actual fire alarm, please exit by the door through which you entered and follow council staff down the stairs onto Union Street. Please do not use the lifts. If you have any access requirements, please let us know, as refuge and evacuation facilities are available. As the Inspector has already said, the events are being live streamed. Please note that the audience will not be recorded, but if you wish to ensure privacy, the 2 back rows will be completely out of view of the cameras. During sessions, please can those people not participating please keep noise levels to a minimum. Thank you.
Okay, thank you very much. I'll now turn to my colleague David Troy.
I'm just going to say a few words about the submitted plan and the modification process. The starting point for the examination is the submitted plan, which is the Sheffield Local Plan December 2022, published for consultation between the 9th of January and the 20th of February 2023, and which is submitted to the Secretary of State for examination on the 6th of October 2023. Our role is to assess whether the plan satisfies the requirements of the 2004 Act, the relevant regulations, and whether it's sound, that is, positively prepared, justified, effective, and consistent with national policy as defined in the MPPF. Just to clarify, the plan will be assessed against the September 2023 version of the National Planning Policy Framework, i.e. the MPPF, and not the more recent version published in the December 2023 because of the transitional arrangements that relate to this plan. In terms of soundness, there are 3 possible outcomes to examination. The plan is sound and no modifications are necessary. That's very rare. The submitted plan is not sound, but will be made sound by changes if necessary, following further work by the Council, or the submitted plan is not sound, but cannot be made sound by so changes made. In terms of the modification process, once the plan has been submitted, there are only 2 ways in which changes can be made. Main modifications recommended by the Inspector and additional modifications made by the Council on adoption. The Council has formally requested that we recommend any main modifications necessary to make the plan sound, and has proposed a number of changes to the plan for us to consider. However, we can only recommend main modifications if they are necessary to resolve problems that would otherwise make the plan unsound. Main modifications are changes that will materially alter the plan or its policies. In the interest of fairness, they will need to be subject to consultation, potentially after the hearing sessions, and further sustainability appraisal and amendments to the habitat regulations may also be needed. Additional modifications are changes which do not materially affect the policies of the plan. They are made by the Council on adoption and are sometimes referred to as minor modifications. Additional modifications do fall not within the scope of the examination, and it's the Council who is accountable for them. Generally, they involve factual updates and corrections of typographical errors. The Council has already started compiling a list of potential main modifications, which are included in a schedule of suggested amendments document, CD 31 in the core documents list for the examination, and also has put forward a number of main modifications in the hearing statements. During each hearing session, we will run through the Council's changes. We've noted that some changes in CD 31, the schedule of main modifications, could be minor rather than main changes, but we will deal with this as we go through the agendas. We'll also discuss any proposed changes put forward by other participants around the table. By the end of each session, we will aim to ensure that the Council understands what main modifications are needed. In some cases, further work by the Council may be necessary, or we may need time to confirm our position, and we will write to the Council as soon as possible after the hearings are closed. As the hearings progress, can we request that the Council prepare a running schedule of the main modifications that are agreed? The Council was also requested to keep a running schedule of action points arising from the hearing sessions. The main modifications and action points can either be combined into one document or 2 separate documents. We will go through that list at the end of each week and check that they tally with the Inspector's versions. The schedules will form a record of discussion at the hearing sessions and will be published on the examination website. I'll now hand over to Rosie Morgan.
Thank you, David. Can you all hear me? So just a few words about the purpose and format of the session today. So many people around the table are familiar with how the hearing sessions run, but just as a reminder, it will take the form of a structured discussion based on the agenda before us. So it's an opportunity for us as inspectors to find out more about particular matters, and also an opportunity to comment and express your views. Our initial questions will often be to the council, but there will be plenty of opportunities as well during the session for everyone to speak. And we will invite contributions at various points. If at any stage you want to make a point, please place your nameplate on its end, and we'll bring you into the discussion as soon as possible. And then when you come to speak, if you press the big button at the bottom of the microphone in front of you and then turn it off afterwards, and please put your nameplate down as well, so we don't keep coming back to you. We've got plenty of issues to discuss, so if you could just keep your points short and focused, that would be appreciated. We've already read the representations on the plan and the hearing statements, so you don't need to repeat all of your submissions. You may just wish to highlight any key points. So just as a reminder as well, no further written submissions or evidence should be submitted at this stage unless we have specifically requested it. So for today, we haven't specified a morning-afternoon break in the agenda. We are anticipating that we may potentially complete items 2 to 4 by lunchtime. That's item 4 is the integrated impact assessment. We might get further than that. We'll take a lunch break at that point, possibly sometime between 1 and 2, but 12 and 1. We'll see how we're going on as to the timings during the day. We'll also have a mid-morning and mid-afternoon break of around 15 minutes. So noted what you said about the fire alarms going off at 11 as well, so that might be an opportune time to have a break anyway. But we'll see how we're getting on. We'll usually aim to finish by 5 o'clock at the latest. Hopefully today, looking at the agenda, it might be well before that, but say we'll see how we're getting on. So if we just turn back now to Katie.
Thank you. Yes, before we get to the main agenda, if we could just now do the introductions. So if I could go around the table and ask everyone just to say your name and your organisation where relevant. If I could start, please, on my right with the council.
There we are. Simon Vincent, Strategic Planning Service Manager at the Sheffield City Council.
Good morning, my name's Miss Sarah Reid, King's Council, it's REID, and I'm assisting the local planning authority.
Hello. Oh, it's not got a red light, this one, sorry. My name's Laura Stevens. I'm the local plan team lead from Sheffield City Council.
Good morning. I'm Mike Johnson, Head of Planning at the City Council.
Ian McCluskey from ACOM. We have helped the council with the integrated appraisal.
Stuart Ireland from ECAS, and we've assisted the council with the Habitats Regulations Assessment.
Chris Hanson, Principal Planning Officer at Sheffield City Council.
Sorry, I missed your surname.
Oh, Hanson.
Good morning, Paul Wheatley, representing Sheffield City Council.
Morning everyone, I'm Will Stewart, Director of Investment, Climate Change and Planning at Sheffield City Council.
And this one's not working, but this one is. Roland Bolton, DLP, representing Inspired Villages and Hallam Land Management.
Sorry, I didn't hear you say that.
Roland Bolton, as in the town.
Thank you.
it on? Can't see the red light.
Morning, Mum. It's Andrew Rose from Sporforth, representing Ruler Developments and Strata Homes.
Okay, thank you everyone. Does anyone have any practical questions about how the hearing session today will run before we move to the agendas? No? Okay. In that case, I will invite the Council then to make a short opening statement. Thank you.
Thank you, Mark. First of all, we would like to welcome the inspectors and participants to Howden House for the examination hearings. We'd also welcome members of the audience, both those here in person and those watching online. We'd also like to welcome the Programme Officer, Ian Kemp, and also thank him for helping us to reach this point. I'm sure we will be thanking Ian many more times over the coming months. We've done introductions. Just to say we will be calling on various other members of the team at various hearing sessions. We will also be asking some of the consultants who were commissioned to prepare the evidence base for the plan to contribute where relevant, and we will introduce them at the relevant stages. We're pleased that after extensive work on consulting and preparing the Sheffield local plan, what we're calling the Sheffield Plan, that we've reached the examination stage. The plan has been prepared in accordance with national policy and regulations and has been subject to 3 public consultation periods covering 2 Regulation 18 consultations in 2015 and 2020 and a Regulation 19 consultation at the beginning of 2023. Public consultation has been undertaken in accordance with the Statement of Community Involvement. In considering the overall scale of growth, spatial approach and site allocations, the Council has listened carefully to what people told. We would like to thank the numerous colleagues from those organisations who have supported this work. This is a plan for the people of Sheffield. It sets out the growth strategy to 2039 and ensures that the benefits of development are felt across all communities. During public consultation, certain themes and issues received significant comment. Many people attached great importance to protection of greenbelt and open spaces. Sheffield was, of course, one of the first cities to ever have a greenbelt, the earliest maps dating back to 1938, so even before the 1947 Town and Country Planning Act. Many people told us about their concerns relating to climate change, about the impact of development on biodiversity, and about the need for good quality housing. People told us about the need for better public transport and to prioritise cycling and walking, about the need for a more vibrant and dynamic city centre, and there was widespread support for the reuse of vacant and underused brownfield sites across the city. The plan reflects and, where necessary, balances these priorities. The Council understands that housing is often at the root of inequality. The Council therefore remains steadfast in its commitment to truly tackle this and provide a high standard for all our neighbourhoods, but balancing this with the objective of ensuring that the city's green spaces, greenbelt and countryside are protected. During the evolution of the plan, there have been changes to the planning system, most notably the change in December 2020, after the Council's Regulation 18 consultation had taken place, which altered the standard method for calculating housing need. This added a 35% uplift to Sheffield's housing need, as well as to those of the 19 other largest urban centres in England. You will no doubt hear representations stating that the plan does not provide for the 35% uplift and will not therefore deliver enough housing. There will be others who will argue that it won't provide enough employment land. The Council has considered these issues very carefully. National planning guidance tells us that the increase in the number of homes to be delivered in consequence of the 35% uplift is expected to be met in the city itself, unless this would conflict with national policy and other legal obligations. In addition, it tells us that in considering how need is met in the first instance, brownfield and other underutilised urban sites should be prioritised, and on those sites, density should be optimised to promote the most efficient use of land. This is to ensure that homes are built in the right places to make the most of existing infrastructure and to allow people to live nearby to the services they rely on, making travel patterns more sustainable. The Sheffield Plan directly reflects these priorities. It seeks to maximise urban potential. It maximises the use of brownfield sites in the urban area and makes efficient use of land. It fosters sustainable patterns of development. Its urban capacity-led approach is therefore appropriate and is consistent with national policy and guidance. However, Sheffield is a Greenbelt authority. Even after applying its urban capacity-led approach, meeting the council's housing need in full, including the 35% uplift, would mean very significant Greenbelt release. Allocating additional land for employment purposes would also require Greenbelt release. The council's evidence base demonstrates that the Greenbelt continues to play an important role in Sheffield. In addition, it shows that the urban capacity-led approach will deliver sufficient homes and jobs to support the council's growth aspirations. It's consistent with growth objectives within the wider city region, will encourage urban regeneration and renewal, and will foster sustainable patterns of development. Carefully balancing the relevant objectives and priorities, the council has concluded that there are not exceptional circumstances for Greenbelt release in Sheffield, and that the application of the relevant national policies relating to the protection of the Greenbelt provide a strong reason for restricting further development in the plan area. This is therefore a plan for sustainable development that accords with paragraph 11 of the National Planning Policy Framework, or MPPF. The new plan is nevertheless ambitious, particularly when compared to past growth trends. It is a plan that will enable over 35,500 homes to be built and over 43,000 new jobs to be created, delivering the ambitious economic growth targets agreed by the South Yorkshire Mayoral Combined Authority. We believe that those growth figures align with each other, and we have provided evidence to support that conclusion. So even though additional Greenbelt release is not proposed, this is a positive plan that will facilitate and deliver the city's growth ambitions. Some objectors to the plan will argue that major growth of the central area is unviable. But it is clear from just walking around the central area and from the City Council's own monitoring evidence in respect of recent completions that significant growth is already being delivered in Sheffield. The Council considers that its plan, which seeks to make the best use of brownfield land and foster urban regeneration and sustainable patterns of development in accordance with basic principles of good planning, is aspirational but realistic. The climate emergency has played a key role in shaping our thinking. Sheffield, along with other cities and regions around the world, will need to play its part in responding to the biggest challenge of our time. The plan focuses future growth in the existing built-up areas and seeks to raise overall densities. It will help to make neighbourhoods better places to live, reduce the need to travel, and help us to improve public transport, shops and local facilities. The plan takes forward the ambitions for the city centre that we set out in the Sheffield City Centre strategic vision in 2022. It includes proposals for a series of vibrant new neighbourhoods and providing homes, new public spaces and local services and facilities. The Council recognises that it will need to work with the people of Sheffield, landowners, developers and other partners to deliver those neighbourhoods over the coming years. These new city centre neighbourhoods will have clear identities, offering a variety of places and experiences. They will be designed to be inclusive and play a significant role in sustaining existing and future businesses across the central area. We have already made significant progress with partners, including Homes England, to realise this vision. The plan will play a vital role in helping us to drive up the overall quality of new developments. Amongst other things, it sets improved space standards for new homes, will deliver more accessible and adaptable housing, and require new development to cut carbon emissions, supporting the Council's clear ambition to be net zero carbon by 2030. The Sheffield Plan is supported by an infrastructure delivery plan that will help us plan new infrastructure more effectively. This includes the provision of new education and health facilities, as well as other vitally important improvements to public transport. Indeed, better transport infrastructure is crucial to delivering the new development proposed in the plan, and many of the policies designed to support the creation of neighbourhoods where everyday needs can be met within a short walk or cycle ride without always needing to use a car. A shift to more sustainable ways of travelling will be essential, not only to cut carbon emissions, but also to create safer, people-friendly neighbourhoods and reduce congestion. We believe we have developed an ambitious Sheffield plan that is for today, but also the future, playing a significant role in creating a truly sustainable city. Thank you. That concludes the Council's opening remarks. Thank you.
Thank you very much. Right, that takes us on then to the main part of the agenda for today in item 3. Just doing a quick overview of what we're going to talk about in terms of the programme for today. So item 3 is on plan preparation and consultation. We've just got a few questions about that just to check our understanding. And David Troy will lead on item 3. Then under item 4, we're talking about the integrated impact assessment, looking at the council's approach and whether it's compliant with legislation. We have a number of questions under this item. I suspect there may be interest around the table as well from others. So we anticipate this probably will take the main part of the morning session to deal with that. Rosie Morgan will be leading on this item. Just to say that the Council produced a new evidence document last week, an explanatory note which suggests that further testing of employment options should be undertaken. Can I just check that the others around the table have seen that? Yes, okay, thank you. Then under item 5, we'll be talking about the Habitats Regulations Assessment. The Peak District National Park Authority will be joining us for that item. Natural England were due to attend but unfortunately cannot, so they've submitted a short statement instead. Can I just again check that others around the table, if you wish to see that statement, have done so? Okay, thank you. Then under item 6, David Troy will be leading on this matter. He has a few questions for the Council on procedural matters. And then under item 7, if you wish to make any other comments on legal or procedural matters that aren't covered under items 3 to 6, please could you raise them at this stage. We'll then move on to matter 2, which is the duty to cooperate, and David Troy will be leading on this. He just has a few questions for the Council on engagement processes and particularly the issue of logistics, which I understand is an outstanding area of disagreement with other authorities. So as I said, just as we said rather before, it does look like we'll probably be finishing the agenda before 5, but obviously we'll just see how we get on. Right, I'll now pass over to David Troy then for item 3.
Okay, thank you. Basically, obviously, there was the matters, issues and questions that obviously set out a series of questions. I've had the responses to those. So I've just wanted to tap into a few individual issues, starting with the plan preparation and consultation, which the question was obviously MIQ 1.1, but just really the question I had was in terms of the plan preparation and question 1.1, have all relevant groups and individuals been effectively engaged during the different stages of the local plan process? In particular, have the general consultation bodies defined in Regulation 18 of the Town and Country Planning Act, Local Plan Regulations 2012, and listed in the Council's Statement of Community Involvement been engaged, including bodies that represent persons carrying out business in the local authorities area, bodies representing interests of different racial, ethnic and national groups in the authority area, bodies representing the interests of different religious groups, and finally bodies representing the interests of disabled persons. It'd be just useful under each of those sort of headings, general consultation bodies, if you might give some examples maybe of how those particular general consultation groups have been engaged. That'd be useful, please. Thank you.
Thank you. Yes, so I can confirm that all the consultation bodies set out in the 2012 regulations have been engaged at both the Regulation 18 and Regulation 19 stages of plan preparation. We set out details in the Council's consultation statement, which is CD 23. It sets out how specific consultation bodies were engaged, having regard to the plan-making regulations and the approach set out in the Council's Statement of Community Involvement in 2020. It included statutory bodies, relevant authorities, general consultation bodies such as local amenity groups, residents groups, businesses and individual residents. So we did particular consultation with the Sheffield Property Association, with the Access Liaison Group, which is a body of a group set up to represent the interests of disabled people in the city and meets to discuss various planning issues. So we've had a number of sessions with that group. We also engaged with the women's group, and there were series of thematic events with black and minority ethnic groups as well, held across the city. So we have engaged with all those different groups, and I say more detail is provided in Appendix 1, Section 2 of the consultation statement, and which deals with the Regulation 18, and in Appendix 2, the Regulation 19 consultation and how that was undertaken, and details of who responded and who we approached, and the various events that were held as part of those consultation periods.
Okay, if there's any comments there, Mr. Rowland, you've got a question?
Yes, and my point isn't about whether or not the engagement has taken place, but is about effective engagement. And in our submissions to you, the first point is the point Mr. Vincent has made, was that the Regulation 18 objective and issues consultations took place before there was a new standard method for calculating the housing number, and therefore there hasn't been, if you like, a proper consultation on what that number is and how that need could be met. The second point is turning to CD20. CD20 suggests that, and paragraph 2.8 of CD20 suggests that sufficient provision will be made for housing and employment. Now, quite clearly, and the council accept this, that it does not make sufficient provision for housing, because it is not going to meet the standard method. So the point is reiterated again in CD20. So therefore, can one have effective engagement when one hasn't actually set out the issue properly before the population? Furthermore, when one looks at the plan itself doesn't mention the standard method at all, doesn't mention what the higher requirement is. And if you look at bullet point in paragraph 2.12, it tends to suggest
2.12 where?
Of deposit version local plan, Regulation 19 plan. And it's the bullet point, second bullet point under objectives for thriving neighbourhoods and communities. It states to ensure Sheffield has an adequate supply of residential development land so the city can meet its requirement for new housing. Well, certainly it's not meeting the standard method. It is meeting, as the council correctly have told you today, a capacity-based number. It's the next paragraph, which is paragraph 3.3 in the local plan on page 20. It says Sheffield's development needs will be met, or Sheffield's development needs to 2039 will be met within the existing urban areas without the need to remove land from the greenbelt. Well, that's standing on its head, basically. What's being proposed is that only those needs that can be met within the city boundaries are going to be met, because the political decision...
Could I just say, obviously, I'm really trying we're obviously going to have discussions on the housing need. So if you could just focus your actual points really about plan preparation, consultation at this stage.
That's exactly
legal procedural, please.
That's exactly what I'm trying to do. What I'm not making the point about the numbers. What I'm making the point about is whether the public consultation has been effective or whether it's been misleading. And my view is it's been misleading because it's not told the public what the standard method is, what the requirement is, and it's presenting in the plan, in its written form, a different position to what's being presented to you in the evidence here. The evidence here is that this is a capacity-based plan, and it's not meeting housing needs. And that should have been put fairly and squarely in front of the public, and it hasn't been.
Okay, as I said, I don't really want to get too much into housing need issue, but is there any sort of comments on effective consultation on this particular point in terms of this particular matter at this stage? I know we'll be going into it much later on.
I mean, so just obviously I'll pass over to Mr Vincent, but there's obviously a difference between housing need and a requirement figure in a local plan. And the requirement figure in the local plan is the requirement figure in the local plan, which is different to the standard method figure in respect of need. No doubt we'll come on to that in due course, but the Council rejects the argument that's being made that consultation has not been effective. And in respect of the position statement that's being referred to and the statements of common ground, we'd obviously ask you to read that, and I know you will read them in full, of course you will, read those in full, because they do make it clear, actually, that the relevant consultation bodies have been consulted and on the correct basis. Trying to find a paragraph reference, but I'm not quite quick enough to do that at the moment, I'm afraid. But I know it's there, because I looked at it in the context of Mr Bolton's comments before, so there we go.
Thank you very much. I'm just going to move on to if you just put your name if you don't want to ask any further questions at this point, Mr Bolton. Thank you. So I'm just going to move on to the statement of community involvement. Thank you. Just in terms of statement of community involvement that was published in 2020, is it still relevant and up to date? Does it cover all the current relevant stakeholders, including statutory bodies, general consultation bodies, groups, individuals that may be affected or will be affected by the policies and proposals in the plan? Just get a council response. Thank you.
Yes, the SCI published in July 2020 is still relevant and complies with national planning policy and acts of Parliament. There's detail of that within Appendix 3, page 23 of the SCI. There are a few minor updates to the SCI which could be made, but these do not affect the content and purpose of the SCI. Just refer to those perhaps in a bit more detail. It could make reference to the October 2020 issues and options consultation. That should be included. It could include there could be updated references to the most up-to-date MPPF, obviously, which has changed several times, and an updated reference to the October 2021 LDS. But I think fundamentally it doesn't affect the content and purpose of the SCI and the steps around consultation and engagement with different groups that was at its heart, really. Just one further point is that the database portal has been replaced and updated, and therefore the links don't work. So there are some technical things around the SCI which would need updating, but I don't think it affects things materially. Thank you.
Thank you, Mr Vincent. Just one supplementary question. Just in terms of key relevant supporting documents evidence, was that available to view during the consultation period on the pre-consultation plan? Are you comfortable that basically everything, all key supporting documents evidence was available during that consultation period?
Yes, all supporting documents were made available during the consultation periods at both Regulation 18 and Regulation 19.
Okay, Mr Bolton, you've got a comment, I believe.
I just want to quickly comment on the point that was made by Ms Reid about the difference between need and requirement. The references I gave you refer to housing need, and housing need is defined in the MPPG and the MPPF in paragraph 61, which is the actual overall need. The requirement is what's set by the plan, and the plan states it's meeting housing need, which has to be in accordance with the MPPF. I would accept if it had said it's meeting its housing requirement, that would be different, but it's not. I mean, it is meeting its housing requirement, it's just not meeting its housing need. Two different things. Ms Reid was right. But
thank you, Mr Bolton. Yeah.
It does go to the absolute central issue here about public consultation and whether it's been up front, and I don't think it has.
Thank you, Mr Bolton. Just going to move on just to the final point in this section, is just about the local advance scheme. In terms of the timing of the Sheffield Plan set out in the local development scheme, including its adoption in December 2024, is that still realistic? Does the sort of the local development scheme published in October 2021 need to be updated to reflect slippage in the plan programme? We just get a response from the council. Thank you.
Yes, as I think we've set out in our written statement, WS1/1, paragraph 1.3.3, that table 1 in CD21 sets out the Sheffield Plan timetable, so CD21 is the local development scheme. As we said, consultation on the draft plan under Regulation 19 took place 2 months later than was shown in the LDS, and submission of the plan was in October 2023, so 5 months later than is shown in the LDS. So consequently, we do expect, obviously, the examination will extend beyond, we know the examination is going to extend beyond September 2024, and this means it's unlikely the plan will be adopted by December 2024 in the LDS. So, yeah, we can make an update to the LDS if the inspectors think that is appropriate. The council has made council members aware of the possible and actual delays to the LDS timetable due to the scale and nature of the representations and how much requires examination in the public hearing. So there was some additional evidence that needed to be collected, which caused some delay. This was set out in council committee reports that they were publicly available, so there was public, the public were made aware of delays in the overall timetable. But as I say, we can do an update to the LDS if required.
Okay, thank you. If you just note that as an action point, just on the schedule, then please just obviously noting what's just been said as our first action point in terms of the LDS. Obviously, if that is something the council are willing to sort of review, then we, obviously we can take that on board. Thank you. Just a supplementary question, really that stem from the LDS itself, the local development scheme. Just could I get an update on the joint South Yorkshire waste local plan? It's covered in the LDS. If we could just get an update on that, thank you.
Yeah, so the joint waste needs assessment produced by the 4 South Yorkshire authorities, that was completed in April 2022. There is a memorandum of understanding, which is exam 4D, which was agreed in December 2023, and that's an agreement to progress a joint waste plan between the 4 South Yorkshire authorities. The 4 authorities are now working through the approvals process to publish an LDS for the waste plan, and the current intention is that to be published next month, in fact, in July 2024. So the indicative project plan at the moment, this is obviously would need to be confirmed through the LDS, is to procure consultants in August 2024, issue a call for sites in autumn 2024, undertake the Regulation 18 issues and options consultation by summer 2025, Regulation 19 publication spring 2026, with examination in late 2026, early 27, and adoption by summer 2027. So that's the indicative project plan that we're sort of working to, that needs to be worked up into an LDS.
That's helpful. Just on terms of just neighbourhood plans as well, I noticed obviously in the current LDS is reference to a number of neighbourhood plans, but I just could give an update on the status of the Kelham Island and Neepsend neighbourhood plan, the Ecclesfield and the Stocksbridge, and also are there any other neighbourhood plan designations that have taken place since the publication of the local development scheme?
Yes, I mean, currently we only have 2 made neighbourhood plans in the city. What's called BSc neighbourhood plan, which stands for Broomhill, Broomfield, Endcliffe, Summerfield and Tapton, so that's BSc. And the other one is the Door neighbourhood plan. So they were both adopted in 2021. The only one that is actively progressing at the moment is the Ecclesfield Parish neighbourhood plan. consultation on the draft plan commenced on the 14th May this year and will end on the 12th of July 2024. And the plan-making body intends to submit the plan to the council in autumn this year. With the Stocksbridge and neighbourhood plans, these have effectively stalled. The neighbourhood plan area was designated for Stocksbridge in February 2024, but the group have not progressed anything further with that. The Kelham Island and Neepsend neighbourhood plan forum and plan area were designated for 5 years in February 2019. The designation of the forum and plan area therefore needs reviewing, so it has the period has the 5-year period has ended. Our understanding is that the individuals who form the forum may not wish to progress the neighbourhood plan. Yeah, just to confirm, the Stocksbridge designation was in 2014, so I don't know whether I made that clear. Yes, I think that's the update.
Okay, thank you. So there's no other designations at this stage, no other neighbourhood plan designations that you're aware of that have taken place since the publication of the ODS?
No.
Okay, thanks very much. Unless there's any other matters that anyone wants to raise on the plan preparation and consultation on this part of the actual agenda, we'll move on to the integrated impact assessment discussion. Sorry, Mr. Bolton. Yeah, sorry.
Just to give the examination benefit of my experience of dealing with capacity-based plans, the timescale going forward might need to include your assessment of individual alternative sites to check that the capacity is what the capacity is claimed to be, and that can be quite a long process. Well, in Hatfield, I think the examination started in 2017 and has only been adopted this year. I've been a participant of that process, and therefore just some realistic approach, I think, in terms of what you might need to do and the additional work you might be requiring the council to do might mean that even the amended timescale given by the council is optimistic.
Okay, thank you, Mr. Bolton. Okay, I think we'll just move on to now the integrated impact assessment discussion. Thank you very much.
Okay, thank you, David. So as we mentioned previously, we'll be talking in this session about the integrated impact assessment, IIA. Just focusing today on the process and methodology and whether it meets the relevant requirements in the SEA regs and legal requirements. We won't be going into the particular merits of the various options that the council selected. That will be covered in later sessions this week and next week. There's just got a couple of questions about some of the documents that have been produced before we go into the sort of more detail about the methodology. Can I just ask, is there a non-technical summary for the IIA report from 2022?
Well, obviously there should have been one, but one was produced, but unfortunately I'm instructed that due to an oversight it wasn't published. Now, obviously, we accept it's a requirement, it's a legal requirement for it to be published. The IIA is an iterative document and there can be consultation later. You'll be aware of our proposals in other respects in terms of that. So the Council recognises that it will be necessary to publish a non-technical summary and consult on it, and our proposal is to do that. Having said that, because it's also proposed that there's going to be an addendum, we thought it would be sensible to produce a single non-technical summary encompassing the IIA and the matters included in the addendum, which is why we haven't published we haven't produced that for you to have a look at in advance of this session.
Okay, so we'll go on to talk about the addendum and the timetable for that, but yeah, so obviously, yeah, just have to make sure that that's all done.
Yes, absolutely.
Together.
It's absolutely on our radar, and
Okay.
we are aware of that. Thank you. Thank you very much. Yeah.
We're going to add that, I think, to the action points, just for the avoidance of doubt.
Okay, yeah, thank you. And can I just check the documentation refers to an interim IIA report from 2022. I think it was where you did the greenbelt options. Was that a separate document that you consulted on, or was it part of the main report?
Yes, perhaps I can just clarify that point. So there was an interim IIA published alongside the Regulation 18 Issues and Options document. And I think perhaps there was some confusion with the language in the final IIA, which referred to an interim IIA. That was really just an internal draft of the final document, but relating to the greenbelt elements. So the original interim 2018 IIA fed into the draft final IIA, but was used to inform discussions with members on the overall spatial approach in early 2022. So the internal draft of the final IIA, in one or two places, it does make reference to an interim IIA, but it was an internal document. There was no consultation on an interim IIA in 2022. The internal draft was produced by ACOM in February 2022. It refers to potential locations in the Greenbelt. I think importantly, that's all covered in section 7 of the final document, so the content is in the final IIA CD17. So that's where it's all covered there. The IIA itself was published alongside the Regulation 19 plan and was available to members when they made the decision to submit the plan in September 2023.
Okay, thank you for clarifying that. So just, yeah, it wasn't entirely clear. And the only other final thing I just wanted to check on sort of the documents was the 2020 scoping report. Was that consulted on? Because it was an update to a previous.
Yes, it
report,
was. Yes, that was. Yeah.
And any responses to that consultation? Where are they?
So that will be covered in the consultation, the relevant consultation report.
That consultation report.
Yeah.
Okay, thank you. Okay. So just moving on now to the additional work on IAA, options for the scale and distribution of employment. So this is something that the Council's identified as being needed in response to consultation. Do you want to say something about the note that you've produced?
The Council obviously considers all representations that it receives. So I'm just trying to find a copy of the note, if you just bear with me a second. The Council obviously considers all representations carefully that it receives, and in particular it noted representations from Sporforths in terms of this issue, identifying a criticism that the IIA hadn't fully considered or explained the approach taken in respect of reasonable alternatives for the scale and location of employment land provision. So in terms of what the IIA does, it appraised a range of options relating to the scale of employment provision between 8 and 29 hectares, although that was based on the evidence that was available at the issues and options stage, essentially. So the Council, having considered the representations that have been produced, and in view of that, is proposing an addendum to the IIA to ensure that reasonable alternatives are reconsidered in the context of the most up-to-date evidence available to the Council. Yes, sorry, that's obviously 8 to 29 hectares per annum. Sorry, so the Council is proposing, firstly, that reasonable alternatives are reconsidered in the context of the most up-to-date evidence available to the Council, having regard to the evidence in both the Employment Land Report and the logistics study, which form part of the evidence base that's been produced. And so, whilst 4 options for growth, as I say, that range between 8 and 29 hectares have already been considered through the IIA, it was considered really for belt and braces that reappraisal would be helpful in the context of the most up-to-date evidence to ensure that the basis of the appraisal of reasonable alternatives is robust. And secondly, that reasonable alternatives relating to both the scale and location of employment provision are fully assessed. And so we also note that Sportfoods have indicated sort of a mixed use for its site. So we've indicated in the note as well, just a point about ensuring that that's picked up in the addendum to the IIA. Now, obviously, the IIA is an iterative process, and so we're comfortable that we can do that, and we thought that it would be of assistance to indicate that that was the Council's proposal at the earliest stage, hopefully also to assist Sportfoods in understanding what we are proposing to do to meet some of the representations, I think, that they've set out.
Okay, thank you. Yeah, I don't know if you want to say anything at this stage.
Thank you, Ma'am. Yes, obviously we have seen exam 54, which came through the other day. We welcome the acknowledgement of the Council that actually the IAA, as published, is actually deficient and is flawed. Clearly, we've been making submissions all the way through that actually the plan as published, the Reg 19 plan, is not based on evidence. The evidence that is before you, Mum, and obviously, as you well know, I quite like an evidence-based approach, and the evidence published, the evidence that's actually put forward is actually reflected in the plan. Here, as you've seen, the Council's approach is obviously to try and retrofit and justify a plan approach which actually doesn't match the evidence that's before you. Clearly, we made submissions, and as you've read and as you've seen in our response in terms of Matter 1, Question 1.4, the chronological approach that the Council has actually taken to the plan, and obviously how employment has actually been seen within the plan itself. It was quite interesting, actually, that Mr. Vincent's openings actually didn't really reflect and relate to employment, only in terms of employment as it related to housing. And, well, obviously, we'll come on to the matters around housing and the constrained housing approach within the city. But clearly, there is also evidence in terms of employment, the Employment Land Review and the Sheffield Logistics Study, both of which show that actually there needs to be an uplift in relation to employment within the plan to meet the needs and the requirements of not just the city, but also the city region. It clearly shows that there should be provision in terms of industrial and logistics, and obviously that was the criticism that we made in how that actually played through and related. It's not just a quantitative need, and I think the Council's note makes out as well and reflects our submissions. It's also a qualitative need in terms of location and scale, and the way that you actually look at locations in terms of to meet that need can't just be based on sort of the Council's approach in terms of urban, within the urban boundaries. So this plan does not reflect the NPPF. It does not reflect the vision and positivity. And clearly, as the Council have already acknowledged and accepted, actually, the IIA is deficient as is. And as obviously, we made the submission that actually doesn't even accord with para 32 of the NPPF in terms of that iterative approach and assessing all options robustly and appropriately. So I think where we are at is obviously they haven't assessed all the options. They've not assessed the reasonable alternatives. They've said they will do that now, but obviously they've submitted the plan to yourselves to actually assess. But yet they've accepted there are deficiencies in the way that they've assessed as they've gone along. So I think it's a bit of a quandary, really, as to how we actually proceed from here. because I think they've accepted there are fundamental flaws in actually how they've actually got to this point and actually got to this position. So we welcome the fact that they want to try and rectify that, but clearly I think there needs to be some quite significant updates to the plan once we've actually gone through that. And just the order of the way that they've actually done things, it just seems a bit slightly backwards.
Okay, thank you. Thank you. Well, clearly the note is looking to address the concerns that you've raised. So,
Sorry, can I just say one thing? I think it is just an important distinction. Obviously, we have recognised that we are going to... Sorry, we have recognised, the council has recognised that it is going to carry out further work through the IIA. The council is not accepting the proposition that's just been put that its evidence base is flawed. What the council is saying is that it's going to carry out an update to the IIA to make sure that the testing of reasonable alternatives through the IIA is robust. That is a different thing. Secondly, in response to the point that, well, there's a bit of a quandary in terms of how we proceed, you know, the case law cogent land is very clear on this. It is possible to make amendments and addendums to an IIA as we move through the process, and it's an iterative process that will inform the examination. In the same way, for example, that if you were to suggest main modifications, there might be further updates to the IIA at that stage. It wouldn't invalidate everything that had gone before because it's an iterative process, and providing that process is gone through prior to adoption, that is sufficient in law. So we are comfortable it's something that we can do. We've accepted it's something we should do, and of course it will be something that's done independently and separately. It will not be a retrofitting exercise because that of course would not be appropriate, and that absolutely is not the intention. So I just make that clear in public now. Thank you.
Okay, thank you for clarifying that. The note refers to next steps and publication of a sort of a table. You mentioned in paragraph 4.8, sort of just looking at the scope of the note and what it would cover. Table 1, providing some indicative options for the range of need, and table 2, indicative reasonable alternatives. So just in terms of when those would be available and the timetable for producing those, and then to go on to do the addendum.
Yes, well, we're already on with looking at those. We anticipated that it would be helpful for both you and those with an interest to see those in advance of the employment session in particular, because of course we haven't produced the addendum yet, so if there are any additional points to pick up, then it would allow us at that stage to make sure that those are also encompassed. So I'll hand over to Mr Vincent to give a more accurate estimate in terms of production of that, but the intention is very much to make sure that there is adequate time for people to look at that before that particular session.
Before the session next Tuesday.
Yes, so we've had some discussions already with the consultants about how long it might take to produce the addendum to the IIA, and their estimate is about 4 weeks to the tables. Next week. The indicative tables will be next week, by Monday at the very latest. Yeah, so we are well on with those indicative tables.
Okay, and so then that's something that we could discuss then at the session on Tuesday.
Yes, I think that would be very helpful actually, because as I say, if there are additional points that are raised that and there are suggestions as to additional points to be considered through the IIA, then if those are picked up sort of at that stage, then it's possible for the council to make sure that those are reflected in the addendum to the IIA.
Okay, Mr Rose.
Thank you, ma'am. Yes, it would be helpful, I think, ma'am, if we, it was one thing I was going to ask a question about, was these tables that aren't attached to the note, because obviously it does refer to the note, tables in relation to the scale of employment that needs to be assessed through the IIA, and also the location of employment as well, through the IAA as well, where that employment could actually be taken. Because that is one thing I think that we have highlighted and I think would be interesting and useful to understand, because clearly one thing that we've highlighted in our submissions was obviously at the moment there is a significant under-provision of employment land within the plan, and it would be useful to understand the implications of that. And also, I think also it's also on the question on how those tables are actually posed and what's actually included in those tables as well. So I wondered if there was an opportunity for us to engage before the IAA is undertaken this addendum, so that obviously our concerns are actually taken into account thoroughly.
There is a item on the agenda for the Matter 5 session on the IAA, so yeah, we'll cover it that, and the note will be on table 1 and 2 will be available, so we can agree the scope at that session.
I'm on. Am I on? A couple of points. Firstly, it is intended that both of those matters, in terms of both scale and location, are going to be dealt with. So table 1 will deal with scale and table 2 will deal with location. And secondly, we would welcome the opportunity to engage with Sporfus in respect of that, because obviously it's your representation that has sort of triggered us looking at this issue. It depends when the note, when the table has been prepared, but certainly once that has been prepared, if there is time in advance of the session next week, then of course we'd be very happy to discuss that with you in advance of the session.
Okay, thank you. Well, we'll await to receive the note then. That's an action for today. Thank you. And likewise, if there's any further need for any additional IIA work coming out of the session tomorrow, that can also be included.
Sorry, to add one thing, just in response to, I think, what Mr. Rose was saying about the consultation process, probably moving on, obviously, after next week. Obviously, you'll have to consult on it. So the examination process is still open. I mean, obviously, we try and deal with most things at this stage in writing, as you appreciate. But obviously, the examination is still open, so there would be the opportunity, if necessary, to hold a further hearing session. I'm not advocating that would take place, but that opportunity is there.
Okay, thank you. So, if that's everything on the note, we move on then to the work that was done in terms of options for housing growth through the IIA. Can you just explain, please, or just give a brief overview of the process that you went through in identifying and testing the options, just briefly, through the IIA?
Yes, as Ms. Reid has said, the IIA has been an iterative process, and the options have become more focused as we've progressed through that process. So the scale of housing growth options were considered at the Regulation 18 stage in September, October 2020. That stage were informed by the government standard methodology at that time, so which was around, I think it was 215 homes per year at that time, so before the 35% uplift. We rounded that to 2135 homes per year plus 50 dwellings replacement allowance, so 2185 per year was the figure we were looking at that stage. And that equated to just under 40,000 homes over an 18-year period. The IIA, however, does consider both higher and lower than the standard method figures, so that's set out in paragraph 6.4.2 of the final IIA.
Is your microphone on?
Oh, can you hear me okay? Sorry, it was just pointing the wrong way. Sorry. Yeah, so what I was saying was the IIA considered higher and lower than standard method figures, and that's set out in paragraph 6.4.2 of the final IIA. Paragraph 312 of CD 55, which is the interim IIA, sets out the alternative options that were considered at the Regulation 18 stage. We've provided more detail on this really in our statement on this matter, particularly in paragraphs 1.4.4 and 1.4.11 to 1.4.15. So I won't go through that in great detail, but it's perhaps just worth highlighting the three options, A, B and C, that were considered at the Regulation 18 stage, where we looked at really options that were sort of an urban concentration versus a sort of more dispersed approach. So option A was looking at all the development within the existing urban area, with around 20,000 homes within the central area, 20,000 homes in the rest of the urban area. Option B looked at 10,000 homes within the central area, but also allowed for up to 15,000 homes within the central area and 5,000 homes in Greenbelt. The figure for the rest of the urban area remained constant. And then option C looked at 10,000 homes within the central area and up to 10,000 homes within Greenbelt. So in that sense, the options considered very broadly the location of development from urban concentration versus lower density, more dispersed development. And that's explained a bit more in the final IIA in section 6.5 on page 16. Really that sets the baseline for how the options were considered. Our statement in paragraphs 1.417 to 1.421 explains why we felt it was necessary to expand from 3 options to 5. We felt that was necessary in light of the change to the standard method. It's also explained in the IIA itself in paragraph 9.1.1 to 9.1.4 that the 35% uplift meant it was necessary to consider a wider range of options catering for an overall. So those 5 options were considered by members in early 2022, culminating in advice from members on the overall spatial approach in February 2022. That's in the committee report, which is exam 15 on the preferred spatial approach, and that's the cooperative executive report. In our view, the overall conclusions around the different options at the Regulation 18 stage remain broadly valid when we were looking at the 5 options. The 5 options that were considered by members in February 2022 still related to different choices around urban densification and greenbelt release. Options 4 and 5, which were looked at that stage, included degrees of greenbelt release that were also refined through the preparation of the plan, and that's set out in the IIA. Paragraph 10.6.14 of the IIA notes that option 4 would likely result in locations that are primarily agricultural land. 10.6.15 notes that the amount of greenfield release would be more substantial and require uptake of land with a greater degree of constraint. The consideration of specific locations that could form part of those options is set out in section 7 of the IIA, and table 7.4 describes scenarios A and B that can be used to further refine locational options by ascribing further importance to constraints. So if you like, there was a long list of greenbelt locations that were looked at, and then that focused down into a shorter list excuse me, of 13 strategic locations, and the output of that is set out in table 7.5. I think, Paul, Sarah, you think we need to add on that?
Okay, thank you for that. In terms of the options that you looked at, specifically in the work that you did on the green belt, the strategic locations that were identified, and the approach of the kind of how you went about doing that and what your rationale was. Can you just give us an overview of that process and what the reasons were for taking the approach that you did, please?
Yes, I'll just briefly explain, then I might pass to Ian from ACOM, who's supported with that work. So yes, as we've set out in our statement, we considered reasonable alternatives for larger clusters of sites as urban extensions, and they were assessed through the IIA. That's largely set out in section 7, which sets out specifically the greenbelt locations that were appraised. Useful paragraphs there are 7.1.4 to 11, which explain how the long list of possible locations that came from the greenbelt review originally was then distilled into a shorter list of 13 reasonable alternatives for strategic growth. Appendix F sets out the parameters that were used for identifying significant constraints within the greenbelt. And I think, excuse me, it's really important to consider in the IIA paragraph 7.1.5 that we take the assumption that all suitable sites in the urban areas would be part of the spatial strategy before exceptional circumstances for greenbelt release are demonstrated. Obviously flowing from that and taking account of the Council's objective of achieving sustainable strategic growth, a scattered or dispersed release of smaller greenbelt sites wasn't considered by the Council to be a reasonable approach in that it didn't represent a strategic approach. In terms of any greater detail around how those locations were actually chosen, Ian, is there anything you want to add on what I've said?
No, there's nothing to add in that respect. I think it might just be useful if we explain why we did that level of appraisal on the greenbelt locations. I think at Reg 18 stage, obviously the Council did some work on reasonable alternatives looking at greenbelt release, but some of the comments that were received at that stage were that it wasn't really locationally specific and it was very vague in terms of it could be anywhere in the greenbelt. So at that stage we started looking at, following Reg 18, when we got involved, we suggested if we're going to look at greenbelt options again, we should at least know where you would be looking to get a more accurate prediction of effects. So that's the reason we looked at those locations. And in discussions with the Council, because there was such a large amount of greenbelt to consider, it was considered useful to kind of whittle that down to the areas that would be more sustainable to look at in the first instance. So that was the purpose of that process. Was in the instance that greenbelt would be necessary, where would we want to look at first? And that helped us to understand the implications of greenbelt release, rather than just saying we don't really know because it could be any of the sites. It was to help with that options appraisal process, really.
Okay, thank you for that. So in terms of the approach to what was a sustainable location, and the approach that you've gone for was to identify larger clusters rather than any smaller sites. Can you just explain that in any more detail, or do you have anything to add on that?
I think Ian can come in on this one in a moment, but I think it's, an important place to start would be to look at table 7.5. What that does is it's really helpful in setting out or considering what the scale of the parameters would be that we're looking for. I think there's also table 7.4 that looks at potential constraints that might be utilised to refine that approach.
So what pages?
Just bear with me a moment.
Page is that, please?
Pages 45 and 46. I think certainly 46.
Yes, page 46. So the IIA refines down the scale of sites. Obviously, if you're starting with the green belt, it's a large area, as Ian already mentioned. So we started by looking at where there were clusters of sites which would naturally form together to create a more strategic location, a strategic alternative. Table 7.5 looks at how then refinement leads to potential changes in locations with potential to deliver strategic growth. Those are set out as scenario A and B for testing purposes, so that the implications of different constraints could be considered. I think I might have misled you, sorry, table 7.4 also. Yeah. Sorry. Yeah, sorry, the parameters are set out in the appendices, just prior to the full appraisals, which are in Appendix H. Sorry, Appendix G. So I think the important part is if the council did consider that greenbelt release was to be necessary, it would need to bring with it significant benefits in terms of provision of new social infrastructure and environmental enhancements, sustainable transport and high quality design. So growth of a strategic scale is more likely to support those improvements. And so in the first instance, the focus was in identifying locations that could potentially achieve those aims. You're trying to jump in, Ian.
Yeah, I mean, I don't really have a lot to add other than just Section 7 takes you through the whole process really in terms of identifying initial locations for growth. And then what we did was identify some more of the hard constraints that are kind of reflected in MPPF in terms of avoiding those areas that would bring about significant negative effects. So the parameters we use were kind of like steer away from the most sensitive locations first and see what's kind of left over. And we used things like flood risk, landscape and biodiversity designations to kind of steer development away from those areas, what you should be avoiding in the first instance. And that it still left quite a lot of locations that were kind of reasonable for growth. But that Section 7 takes you through the different processes we went through in terms of whittling it down.
Yeah, if I could just add one further point on that. I think one output of that, looking at constraints and refinement, is that there's then a double check to assess whether it can still deliver strategic growth. And is it table 7.5 that highlights that in a colour-coded way with setting out the extent to which strategic growth can be achieved when you've looked at different levels of constraints and refinement.
Sorry, just to assist, in terms of that process that accompanies that table, that's set out at 7.5.8 to 7.5.12 on page, I need my glasses, sorry, 45.
Okay, thank you. So you've identified the strategic locations, and they were larger sites and clusters of sites. Did you consider an approach of having smaller sites on the edge of the urban area as part of that? And if not, why?
Thanks, yes. So I think it's important to note that actually within the clusters of sites that were appraised as strategic locations, many of those include smaller sites, not necessarily really small, but smaller sites. In fact, most strategic locations are made up of clusters of smaller sites, which you can see in the maps in the IIA for those strategic locations, SL1 to 13. I think we took our steer really from the MPPF paragraph 142, where if it's concluded that it's necessary to release greenbelt land for development, then plans should first give consideration to land which has been previously developed and or which is well served by public transport. And an approach that splits sites everywhere is not a reasonable alternative in our view, because it doesn't deliver a strategic growth pattern in sustainable locations, which would provide appropriate infrastructure, for example. The IIA section 7.1.9 and 10 on page 20 sets out clearly why individual small sites were not considered.
Sorry, what was that paragraph reference?
7.1.9 and 10.
On page?
Page 20. That doesn't sound quite right. Yes, page 20. I think it is worth noting that the input into the IIA, which came in terms of land to be considered, was an output from the Greenbelt Review that had been carried out previously, and which also did take account of sites, for example, that had been submitted to us at various points by objectors. So those had gone into the formulation of the consideration of strategic locations within that reasonable option.
So you looked at sites that include smaller sites. So what was the reason to think that those individually couldn't be themselves sustainably located in terms of up and close to public transport, potentially, to meet that requirement in the framework?
It's not necessarily an assessment that a single individual site couldn't be sustainably located, because obviously there are a variety of locations with different degrees of accessibility. I think it stems from the next step in terms of reasonable alternatives, which is what is the most sustainable way to grow the city. And the next step, as set out in the framework, is clearly that you begin by looking at strategic approaches to greenbelt release, if that's your next step, if you found exceptional circumstances. And we consider that the most beneficial option to do that would be to look at what would be the most sustainable patterns of growth, which we felt would be strategic locations, which could be more efficiently made sustainable if they weren't already, or they would be more sustainable locations, but they would give considerably more ability to be made sustainable, not just in terms of public transport, but in terms of infrastructure. Just bear with me one moment.
In terms of identifying reasonable alternatives, which may not have been your preferred option, but having an alternative that did look at smaller sites close to the urban area, could that have been something that you had identified and appraised as a reasonable alternative? It's something that others have mentioned.
Bear with me a moment. Yes, I think, just going back to your original question there, I think we felt it was a planning judgment that the next step for considering reasonable alternatives in relation to the growth of the city would be to consider...
Does it go again?
Yes, I think I was about to say that it's effectively a planning judgment.
I think in terms of looking at potential options, even if it wasn't something that was necessarily your preferred option, an alternative reasonable option of having smaller sites around the urban area, is that's something that could have been identified. I mean, I think it's going again.
Yes, you're right, that could have been considered, but the council had determined that that wasn't a reasonable alternative.
Sorry to interrupt, but obviously I'm sure that Rosie Morgan would then go around the table to others as well, but if I could just ask a question about the size threshold, exactly how did you determine that specific level?
So the size threshold for consideration of the strategic locations within the IIA was set at 1,000 homes. Ian, can you note which paragraph that? That's paragraph 7.1.10, which explains why that threshold was chosen.
Sorry, Sorry, can you refresh my memory, please?
Sorry, paragraph 7.1 explains, 7.1.10 explains how that was chosen. But if I refer you to table 7.4, table 7.5, that explains what the potential to deliver strategic growth at each of those locations would be. And what it does is it looks at, going back to what we were talking about before in terms of how the constraints help to refine those locations. Obviously, an impact of that is if you refine further and further using greater consideration of constraints, you get smaller sites. So what that does is that actually sets out the potential of those locations to deliver growth at scale, depending on the level of constraints, from very likely ability to deliver strategic growth at circa 1,200 dwellings, down to very unlikely to deliver strategic growth at a lower level. And that's colour-coded so that you can see how those strategic locations perform at different capacities, effectively, where the capacities have been impacted by the constraints that were used for that consideration.
Mr. Bolton, do you want to?
Yes, if I can assist the examination. Some years ago, myself and a number of other consultants were asked to participate in an assessment of potential greenbelt sites by Sheffield City Council, whereby we spent a number of months, and possibly even years, looking at every parcel of land around the city and looking at how it functions in terms of the green belt, and that information was all fed back to the council. At that time, the council were taking the view that the size of site should be defined, if you like, by the natural boundaries of the site when you looked at it, rather than trying to conflate it into something that it wasn't. A similar approach was taken in Rotherham, which I also participated in, and Rotherham, Barnsley, Doncaster have all got a range of sites being released from the green belt. And without going into the detail, but the benefits of a range of sites of sizes is that actually you get better delivery, because you get smaller sites, you get larger sites, and you get strategic sites, all of which come forward at different timescales and need different levels of infrastructure. The same is true, obviously, a place like Welling Hatfield, Central Beds, Epping Forest, all of which I've worked on, all of which take the process of having both strategic and smaller sites being released from the greenbelt. I've referred to the decision with regard to St Albans local plan, which had a lower target in terms of 500 houses. They only looked at sites of 500 and above. That was found to be unsound by the planning inspector in examining that plan, and I can't think why the approach should be different here. I can't think why the planning inspector would come to a different decision here. Going forward, there is nothing in either the MPPG or the MPPF that suggests that strategic sites are the only way to release greenbelt sites. Certainly, the point is well made that if you are going to amend greenbelt, then you need to make sure that it's not going to be amended at the end of the plan period. So therefore, you need a number of sites. If you look at what the MPPG, the PPG says, paragraph 35, with regard to where should cities and urban centres uplift be met, when we're talking about the extra 35%, it doesn't say it has to be released on strategic sites. What it actually says, brownfield sites first, then underutilised urban sites should be prioritised. And then it goes on, this is to ensure that homes are built in the right places to make the most of the existing infrastructure. and to allow people to live nearby the service they rely on, making travel patterns more sustainable. Now, to my mind, building on the edge of the urban area, where you have existing bus routes, you have existing schools, you have existing shopping facilities, does exactly that. It doesn't require a settlement of the size of 1,000. And why 1,000? You need 1,500 if you are going to provide an infant school, and about 6,000 if you're going to provide a secondary school. So 1,000 seems to be somewhat arbitrary, to say the least. So I don't think there's a basis for this. What you've heard the council struggle with is they were just saying it's a planning judgment. It's a planning judgment. Well, it might be a planning judgment, but you're here to examine the plan. The plan is not meeting its specified need, and the reason you're being told is that there aren't any suitable sites of over 1,000 units, because they've been excluded as not being a reasonable alternative. The smaller sites you've been told are not a reasonable alternative. They clearly are. They are elsewhere in the country. So there's no reason why the council shouldn't have looked at different patterns of development of sites of different sizes coming out from the green belt. I mean, there's quite a lot to go through in terms of what the council was saying, but most of it comes down to we're quite clear that it was just a political decision not to release sites on the green belt except for Norton Airdrome, and they're trying to backfill the evidence to make that to make that seem reasonable. When you look at the IIA in particular, it just deals with one scenario that would meet the full needs and doesn't really go into any detail of how that can be achieved. I think there's a number of scenarios in Sheffield where you could achieve the levels required, and there would be significant benefits, because what the assessment doesn't do, it is quite important, is it doesn't make an allowance for the 64,000 people who currently commute into Sheffield at the present time. It doesn't do anything to address that balance. It also doesn't make any allowance for the fact that by the urban concentration, by the concentration of 1 and 2 bedroom apartments in the city centre and the surrounding, that it is not meeting its overall housing needs, or indeed the needs for families and older people. And those needs are being met elsewhere. For example, when I opened DLP here back in the 90s, when we grew, we actually had all of my workforce could walk to work. Now, they're coming in from places like Barnsley, places like Drumfield, places like Scunthorpe, because to get the housing they want, the family housing they want, they're moving out of the city. So there's a huge issue here that is if you like, not being assessed in the IAA. The IAA assumes if the houses don't get built, the people won't be here and they won't be coming into the city. And that is a wrong assumption. You have to build in the fact that these people, if they're footloose, as the council described them, for a footloose population, they might still be coming into the city. So you can't just say you get further negative impacts because you have more development. You've got to take into account the fact that these people are around and they'll be coming into the city anyway. So I think you've got to be really, really careful with this. And I certainly remain wholly unconvinced by the answer you've been given with regard to reasonable alternatives. There are clearly reasonable alternatives there. It's absolutely plain.
Okay, thank you, Mr. Bolton. Do you have anything further, Mr. Rose, to add? No. Okay. Thank you very much.
Sorry, I was just taking...
You've made the points right.
Yes, sorry, I was just taking it down so you could see me. Thank you, Mum. Yeah, just a few short points, just to go through the first few bullet points on your next section, really, Mum. So I think what we've heard is obviously how the council went from the 3 options in the issues and options Reg 18 and how we ended up at the 5 options that were presented at committee in early 22. I think, Mum, as you've probably picked up in terms of our hearing statements and our representations, it's obviously all a matter of chronology, but also where the evidence was at that point in time and how that was presented to members so they could make a profound choice. Clearly, where we are, obviously, in the NPPF as it was in then, and obviously in national guidance, it's all about positive planning. It's all about delivering housing and meeting the needs of housing. That's the vision, and that's what the council want. That's the aspirations they've set out, is obviously to deliver housing and employment growth. Clearly, our position, Mum, is obviously the plan does not do that. As Mr Bolton highlighted, and also as you've seen in our statements, it was a political choice where we are at the moment, but it's how that's actually been appraised and how that's actually worked its way through the sustainability appraisal and integrated impact assessments is why we are here now. Our position and our point that we've put forward is that it's deeply unclear how actually that has been appraised and how that's actually been chosen. Because clearly what we have within the integrated impact assessment is that section 10 that seems to justify, post-rationalise the decision that the council have actually made and hasn't actually been an iterative and informed position based on evidence. One of those points, obviously clear, as we've just picked up and heard from the council, is the reasonable alternatives and the consideration of smaller sites. One of the options put forward was obviously option 5, which obviously the council highlighted within the options that were put forward at committee, which is like, you can't release all of that, that's a lot of green belt and that's a lot of small size. But then when you get here, in terms of the integrated impact assessment, it's almost brushed aside, but equally they haven't appraised those sites. Those sites, those reasonable alternatives, and there were alternatives, because a lot of sites were actually put into the council, they haven't actually been considered, they haven't actually been appraised here. It's not evident, it's not published. So how have they actually made that decision? How was that information presented to members? How did they actually make that choice? They couldn't, because the information's not there. If you glibly look at the dates on the IIA and the essay, obviously the essay that was part of the issues and options document, which is the only other published document, is very, very different to what actually we have here. So you can't actually see that it's actually been built upon as you've gone through the process. So I think that there are significant deficiencies actually in how actually the plan has actually been pulled together and actually how it has actually been informed. And I do, honestly, and I would go back to the employment, brief employment discussion, fully support that there's going to be an addendum, but I think there needs to be an addendum here. And actually, I think it needs to go further than an addendum. I think it needs to be a wholehearted update, reconsultation, because actually I don't think this actually presents and justifies the decisions based on the evidence.
Okay, thank you. Thank you, Mr. Rose.
Yeah, well, I mean, clearly the purpose of the IIA is not to justify decisions. It's an independent appraisal of reasonable alternatives. Just dealing with a couple of points. I mean, in terms of Mr. Bolton's point about housing mix and choice, the substantive questions in respect of that will obviously be dealt with in subsequent sessions, so we won't respond to that now. But in terms of your references and the 4 options that were considered in the IIA, 10.3.19 to 25 of that document look at the 4 options and the implications of the choices in respect of housing, housing mix and choice. So it's not correct to say that the IIA didn't consider that, it did. I think those are slightly different points to the point, Mum, that you asked, which was about green belts and how the sizes of sites were selected. And I think, subject to any further questions you have, we've probably answered that. But just to reiterate that in terms of the approach, obviously the 1,000 home was set as a sort of general threshold at the outset, as set out in the IIA. Then what happened was through the IIA process and the appendices constrained sites were effectively removed, and there were two sort of options generally that were looked at. And then in 7.5 you see a sliding scale in terms of what was left and the extent to which that would then facilitate the strategic objectives that have been outlined. So sites less than 300, not very likely to facilitate those strategic objectives, and then right up the scale to, I think it's 1,200 plus, very likely to facilitate those objectives. So that there was information in the IIA in terms of that assessment that then fed into the appraisal of the four options, and you see that when you read the subsequent sections as to how that materialises. So hopefully that assists in terms of the approach.
Thank you. So just picking up on that point then, the appraisal identifies that smaller sites of less than 500, did you say? Less likely to achieve the strategic objectives. Can you just explain how that then fed through into the final preferred option, which does have one smaller site?
Oh, sorry. Yes, bear with me a moment. Yeah, so this is a question about taking forward Norton Aerodrome, effectively. So members concluded that there were significant benefits in redeveloping brownfield sites in the Greenbelt that are in sustainable locations, and that tipped the balance in terms of demonstrating exceptional circumstances for altering the Greenbelt boundary at that particular location, Norton Aerodrome, which is site allocation SS17.
I think the question's about the IIA and how that's considered through the IIA.
Okay, sorry, I've skipped ahead.
Could you just repeat the question, please, so I know I'm answering the right question?
So in terms of the IAA, you looked at larger clusters of sites in order to achieve the kind of strategic goals of development that could be sustainable and provide the infrastructure. But then how through the IIA then did you get to the final option in which you've got one smaller site in the Greenbelt in option 3? I think is that fully? I think it's just how through the IIA you've got from that position to the final option that you're praising. How it's explaining that process.
Yeah, so I suppose as a starting point, option 3 considers release of large brownfield sites in the Greenbelt within it.
I think it's a timing thing, really. I think by the time we got to the point of appraising all the options, I can't see behind the screen, the council, at that point, I think the site at, is it Norton Aerodrome site? There'd been some constraints identified, so that was set as a kind of constant, but it was a bit different to all the other sites, wasn't it, in terms of it forming part of the strategy?
Well, it forms part of option 3 because it's the large previously developed site that's in a sustainable location.
Yeah. Just to assist, Mark, if you look at page 50, which sets out the 5 options that were considered following 35% uplift to the standard method. And so you can see that option 1 is essentially housing requirement limited, suitable brownfield sites in the urban area. Option 1, additional growth by including previously undeveloped land within the urban area. Option 3, further growth by including sustainably located large brownfield locations within the Greenbelt, though there are a range of other mostly small brownfield sites in the open countryside, council consider these are unreasonable strategic approaches given they would lead to unsustainable patterns of growth. To achieve this option, it would be necessary to exhaust opportunities in the urban area, then release Greenbelt land. And then it goes on option 4 and option 5, which lead to further additional Greenbelt release. So the part of the Norton Aerodrome site that's being proposed for allocation falls within option 3 as a one of the large brownfield location. It's because it's brownfield land, so that's why. And then it's also assessed in the site assessment at the end, isn't it? In the essay as well.
Yeah, I think that's where I was leading to when I veered off the IIA, was that the final capacity at SS17 has then obviously been refined to take account of further work, for example, on the extent of the previously developed land at that location, and also ecological constraints that came as a result of the site selection methodology.
And then the site, because the sustainability appraisal deals with the individual sites, doesn't it?
Yeah, the sustainability appraisal reflects the individual sites, and that can be found in Appendix I. Appendix I.
So thank you for that. In terms of the approaches for Greenbelt that you looked at, in terms of the larger sites, and then where you finally got to, the reasonable alternatives that were appraised, would it be helpful as part of any IIA addendum that you're doing anyway, to look at as an alternative, reasonable alternative, another alternative as smaller sites within the Greenbelt on the edge of the urban area?
We can take that away and have a discussion about the merits of that.
Okay. Thank you. Just take the points from Mr. Bolton and Mr. Rose, and then perhaps we'll have a break. Yeah, is it commented in relation to this discussion that we've just been having
Absolutely. First point, and it's point to note in the IIA paragraph 10.14.4, one of the reasons it gives for not for discounting the approach of releasing Greenbelt is it says all the sites perform one or more purposes of the Greenbelt. Well, you would hope they do, because they've been allocated in the Greenbelt since 1968. But that's not the test that you're applying. What you're applying is whether or not there's exceptional circumstances to alter those Greenbelt boundaries, and whether the benefits of doing so outweigh the disbenefits of doing so. And it's the degree to which those sites perform a Greenbelt function. We'll come on to issues about individual sites later, but certainly there are many that perform a very limited function. Secondly, the point was made to you that sites of under 300 houses are less likely than sites of 1,000 plus to meet the strategic objectives of the plan. The strategic objectives of the plan are set out on pages 15, 16 and 17. And personally, looking through those, I can't see any which would or could not be met to some degree or other by smaller sites. They certainly seem to meet most of the objectives. Not all the objectives are applicable to all sites, but it's wrong to suggest that only sites of 1,000 dwellings can meet those objectives. I mean, if that was the case, none of the sites being promoted in the plan would be meeting the strategic objectives, including the urban sites. That's simply not true. Moving on, one of the points about putting sites together and assessing them as of smaller sites, or a conglomeration of smaller sites to make one strategic site, is the impact on the Greenbelt is bound to be greater because you're looking at a greater area. Therefore, you're immediately creating, I mean, this was the point in St Albans, in that effectively they looked at every site plus of 500 houses and said, look, every single site plus 500 houses, it's going to have quite a big impact on the Greenbelt. Well, yes, it will, but the inspectors there quite rightly said, well, actually, those aren't the sites that have been put forward to you. Go and look at the sites that have been put forward to you. What impact do they have? So
the council
oh,
said
yes,
that they'll have a look at that.
Well, it's having a look at it, which is just producing a plan that says we've looked at it, is no good. And I don't think that's good enough here. I think, you know, the plan is unsound. It's not looked at the reasonable alternatives. I think they need to go away and start again, because they do actually need to have a proper look at those alternatives, like St Albans did, like other councils have done. You can do it two ways. You can find the plan unsound, or you can have sessions to look at alternative sites to see on whether or not the council are right in that they cannot be released. You know, if you are going for a capacity-based approach, you can't leave any stone unturned in terms of meeting the housing needs of this country. That's the important thing to be looking at here. I think there's one other point, but I've lost it, so I'll come back. Thank you.
Thank you, Mum. Yeah, I was just listening with interest, actually, around the discussions here in terms of the smaller sites and the consideration of reasonable alternatives. Clearly, when you look at how the council have appraised, you know, you just look at, and your question around the Norton Aerodrome, and clearly how they went from 1,000 homes down to 270 in the Greenbelt, and so quickly changed that scale. Appreciate that the portion of the site that they've identified is apparently brownfield, so that's where they'll put that forward. But clearly still at a strategic level, they've gone below the bar that they've set themselves there, in terms of obviously saying we'll only look at strategic locations, we'll only look at 1,000 homes, and they very quickly went down to somewhere significantly below that. But equally, it's not really reflected or established, especially when you look at the housing section. I can't really see too much reference to that. But then when you get to the end around reasonable alternatives, and the only approach that they've taken in terms of reasonable alternatives, and they've only looked at the 5 options that they presented to members, meeting full housing need with 35% uplift is major positive effects, ? Which seems a bit of a strange one, whereas all the other ones are either major positive effect, or minor positive effects, but no question mark. It seems a bit strange, that. I don't quite understand why that one, you know, against that. I don't just check to see if it's like that in any other. Yeah, they've got quite a few question marks on quite a few other reasonable alternatives in other sort of chapter headings, which is quite an interesting thing, because therefore, how have they actually taken that informed decision as they've gone through? But equally, reference was made towards sites being assessed in Appendix I. My reading of Appendix I, correct me if I'm wrong, is actually just the sites that they've actually included in the plan, because the sites that we've put forward don't appear in Appendix I. So again, how have they actually taken that decision from an SA perspective to actually inform how they've actually presented that to members? So that is actually, this all feels like it's all after the horse has bolted. It's not actually been done as they've gone through the plan, which is what an SA should be. Thank you.
Mum, I've just remembered what it was. I'd forgotten, and I apologise for that. And it's a question for the council, really, through yourselves. We hear that developments of 1,000 units are the appropriate strategic scale because they will deliver infrastructure. I've not understood, or maybe I've misread, I can't find what infrastructure is expected to be delivered on sites of that size. Why those sites have been chosen, we've been told it's because it will deliver infrastructure. What is the infrastructure that is expected to be delivered on sites of that size? I think that would assist you in your consideration.
Okay, thank you. So I think we'll have a break now, but perhaps if you could consider, in light of the discussion this morning, whether it would be, as an action point, whether it would be useful to consider As an additional alternative to be appraised, looking at smaller sites.
And just, I mean, just Mum, obviously we'll go away and have a think about that, but just in terms of what that might look like, I assume there might be some then discussion about, you know, what smaller site means and what that might look like, because, you know, how long is a piece of string in terms of what we're being asked to consider. But in the first instance, we'll have a discussion. Thank you.
Thank you. Thank you.
Yeah, just before we break, I just wanted to kind of pull back a little bit on what we've been talking about in terms of the options and try and explain what it is that we've done, right? Because I think there's a lot of confusion around sites, small sites, big sites, and what we've looked at. What we've looked at in the IA is not a site selection process. We've been looking at strategic alternatives. So in terms of Greenbelt release, you'll see lots of authorities across the country. I'll simply just say their option will be, should we release Greenbelt or not? And there'll be no detail around where that would be, what it would involve, and a criticism of that, and I think rightly so, is that you don't know where it's going to be. So you need to have an understanding of the locations of growth. So the process we've been through was to assist in that kind of strategic decision making, not to decide where Greenbelt growth should be, but to assist in, if there is to be Greenbelt growth, a need for a Greenbelt release, where would it likely be? And actually, if you follow through the appraisal, the Greenbelt release options actually score well, and that's because we've ruled out those negative locations first. So I think all this talk about small sites and big sites, I think it's a bit of a red herring, really. I don't think it's relevant to what we've actually done in the appraisal. It's a strategic appraisal of options at that level. It's not site selection. So I think we'll go away and talk about maybe if there is a reasonable alternative for dispersed growth. That's a strategy perhaps. But in terms of getting caught up in all the intricacies of sites, and I don't think that's necessary to go into, because it's at a strategic level that we're looking at. It's not site selection. And I think that's where there's a bit of confusion maybe. I think if the council had gone ahead and said, yes, we do need to release Greenbelt, a lot of this, what we're talking about, maybe then we would have gone and looked at that. But the strategic decision is there's no need for Greenbelt release, and that's been informed by these assessments, which are actually more detailed than most sustainability appraisals go into. Most sustainability appraisals just say Greenbelt release or not. That's it. So the council have actually done more than they need to do. They've tried to be proactive and look at kind of filtering out those sites that would skew things negatively. If we kept all the Greenbelt sites in, all the ones that are really poorly, constrained, then we might be saying things like, oh, it's negative, but actually it comes out as positive in some respects and negative in others. So I think it's a balanced approach, and the idea behind it was to help feed the decision making, really, rather than just being a tick box. And I think that's what we've achieved, in my opinion.
Sorry, I mean, just to add, and it's probably just in response to Mr Bolton again, really, but clearly sort of the legal position is that the council looks at what it considers its reasonable alternatives are. That's a matter of planning judgment. Although that's, that we consider that is adequately explained through the IIA, but we're now hearing an examination, and obviously we take on board the comments, Mum, that you've made, and we'll go away and consider whether that's something further to look at through the IIA. It doesn't invalidate everything that went before, and it doesn't invalidate the process. It's an iterative process that's considered through the examination, and we'll have a discussion about that in the break.
Okay, thank you. Thank you.
Yes, sorry. Yeah, just to clarify, it was basically a concern, a strategic option, definitely looking at the strategic level, not the specific sites level. And I think our concern really just came from that process. Is it a reasonable alternative to look at small sites as an option? Not that it's not your preferred option. Obviously, you've got a very clear preferred option, but it's that difference between reasonable alternatives and preferred option, isn't it? The council obviously have a judgment to make in terms of what's your preferred option, and you've sought to justify that through your evidence base. What we were doing very much was looking at the sustainability appraisal and just saying, okay, well, what is a reasonable alternative? Have you covered all bases? Which is sort of part of our role as well, to sort of check that with you and have that discussion.
And we're very grateful for the input, so thank you very much. And as I say, we'll go away and have a discussion and come back after the break.
Okay, now, so if we can have a a break of about 15 minutes. So if we come back at just after 5 to, is that okay?
Yes, I'm just checking whether we've actually got a room available. We can discuss this in. Have we got a room? Right. Could we just allow perhaps 20 minutes just to... Oh, we have got one. No, 50. Yeah, it is 20,
That would
20
be
minutes.
20 minutes,
Thank
yeah.
you.
Till
Perfect.
5.
Thank you very much.
Thank you.
Oh yeah, no, we actually put that policy in front when we said, because we got it in, we got it in second place, and we got it in April, which actually based on traffic plan. We predicted what happened. What's that first one? No, talking about it. Yeah, sorry, that's not the way. You know what? Email. Yeah. No, we had stuff that was basically they actually published a list of sites, and we have 3 or 4 sites which are in the top 10 that haven't been chosen.
Were you expanding this small village?
No, we were just like, hang on a minute. Those are sites that chosen. The way you meet the rest of you need is you go down the list of what's acceptable. You look at them. Yeah. Don't suppose there's anyone getting a cup of tea or something.
Yeah,
I don't want to throw people.
Yeah. Sorry, that's good because they will see it and they will have
Yeah, I get that. So, yeah, maybe we'll start.
Yes.
Oh, yeah, but you never, you know, plans never fail. I'll never compromise.
Okay, are we ready to resume, everybody? Yeah. Before we start, can I just remind everybody when you're speaking, if you can turn your microphone off and then turn it on when you're speaking and turn it off again, just for the live stream to make sure that everybody can hear properly on that and in the back of the room as well. Thanks. So, have the council had a chance to think about the reasonable alternative?
Shall I answer? Yeah. Yes, and thank you very much for the input. I think in principle the council is happy to undertake some further testing through the IIA of this as a reasonable alternative. I think just a slight concern, and I think it touches just on the point as Inspector Child was just raising prior to the break, that we're not being expected to sort of do a site-by-site assessment through the IIA of every conceivable small-scale site in the Greenbelt. We understand that what's being requested is essentially, or suggested, sorry, is essentially a strategic option which would perhaps encompass, smaller sites on the edge of the urban area within the Greenbelt, sustainably located ones, so some sort of methodology, for example, to identify what that might look like, and so sort of maybe a typology type approach. I think what we'd propose to do, if it would assist, is produce a note in terms of perhaps a suggested approach for further discussion, because we'd obviously just want to be clear that we were picking up the points that had been suggested in terms of any future work.
I think that would be helpful, thank you. Yeah, so if that could be done in any kind of idea how long that would take?
I mean, obviously we'll action that as quickly as possible. I'm mindful we're also sort of finalising the employment table, so hopefully by the end of this week. Is that sufficient?
Okay, thank you. Mr. Rose, do you want to comment on that particular issue?
Yeah, thank you, ma'am. It's welcomed, thank you, that there will be an addendum on the IIA in relation to housing and the consideration of reasonable alternatives in relation to the smaller sites approach. I appreciate it's not a site selection methodology, obviously that's a different session, but it's usual that there is at least some awareness of the sites that have actually been submitted to the council, so the SA can actually appraise those alternatives. That's usually cognizant and seen throughout. I've seen in quite a number, and I appreciate SAs all have different approaches, but there's usually an awareness and a scoring through the SA of the sites, because that helps with the site selection process, which I appreciate is separate. I haven't seen any of that through here, so I appreciate there'll be a note produced in terms of the methodology, in terms of this additional scenario, but I wondered whether it would be welcome, similar to the employment note and the employment tables, that actually that's shared and there's an opportunity to comment, so actually we're all on the same page here.
Is your concern about how individual sites have been appraised through the SA process? Is that?
I think it's all encompassing, that is part of it, ma'am, because I haven't seen an awareness actually of the sites that have actually been submitted and how they've actually been considered through the SA process, and normally there is at least some semblance of understanding. At the moment it looks like there's been various scenarios actually within the SA, but actually apart from those strategic options, those smaller sites, or, well, I say smaller because they're not all smaller, they're just less than 1,000 and they're still quite large, some of them, so have actually been considered through the SA process, and whether that will be picked up in this alternative.
That is a point that was going to come on to anyway in the agenda. So in terms of specific sites and how they'd been appraised through the IIA, that was just something we'll come on to. Mr. Bolton, did you have anything further to add on? the options.
Just really quickly on that. If we're looking at the options, we've been told that the smaller sites won't provide infrastructure. So the assessment needs to, because it will be scoring them differently for not providing infrastructure. Can we just be clear about what infrastructure isn't going to be delivered on the smaller sites, which was going to be delivered on the larger sites, the strategic sites? Because that's a very clear definition that the council made. So if we could just have some clarification, because that will, it will lead to a negative scoring of the smaller sites, and you need to be aware of whether that's a reasonable scoring.
Does the council want to come back on that?
We'll give some thought to it, but in terms of an IIA and the testing of reasonable alternatives, I'm not clear it can sort of look at what each site might or might not deliver, because it's a sort of broader strategic scale in terms of, well, as an option, how does a proposal which would allow the release of smaller sites on the edge of the urban area that are sustainably located, how does that compare against the other options that are assessed? I mean, clearly it's going to need to have a methodology within it in terms of the approach and how what that looks like in terms of what is a sustainable location, what are the parameters for that. But in terms of sort of drilling down into what individual sites can deliver or not, I'm not really clear that is the purpose of the additional work that we're being asked to look at.
It is a broad level, high level sort of strategic option.
Yes.
Yeah. So.
To be fair, the only reason I'm asking is that the council were very clear that the reason why they didn't consider smaller sites to be a reasonable alternative is they did not deliver infrastructure. We all heard that. That's what we've been told. So they must, and I've asked the question through yourselves, what is the infrastructure that's expected on these larger sites? And if we don't know that, then, and effectively, if we don't know that, but we're being scored negatively on that, then how can anyone come to a judgment? It seems crazy.
Is that something that you can...
Well, we can and have a think about it, but as I say, what this isn't looking at is an individual site appraisal and what an individual site might deliver or not. It's looking at a comparison of reasonable alternatives, and so for example the criteria might be sustainably located, etc. I've made my point already, but we'll take it away and have a think about it in terms of the methodology that's appropriate, and then perhaps the appropriate time to discuss whether the methodology that we've provided is or is not acceptable would be once we've had a chance to have a think about that and put that before the examination.
Okay. Thank you.
Without getting into too fine a detail, I think in terms of undertaking appraisals, from my experience, we personally wouldn't be saying small sites don't deliver infrastructure, because they can do when you pool things together and whatnot. It was just more of a strategic sites provide that on-site opportunity a lot of the time, and that's where the council was coming from. So any assumptions we make about infrastructure will be in the IIA, so you'll be able to see clearly what assumptions we've made and how that's affected the scoring.
Okay, thank you. So we'll have a look at the note once it's produced and the methodology, and we can have a further discussion about that if necessary, and we'll move on from that. So just going on to the further points on the IIA. I haven't got too many more questions on this now. You'll be pleased to hear. Can I just ask about just some clarification, please, on table 9.1 of the IIA, which is on page 51. And specifically, for option 3, the total housing supply figure that is at the bottom, is quite significantly above the housing requirement figure that you have for that preferred option. Can you just explain what elements of the supply have been lost? It's just so that we can understand that figure and where it's come from.
Yes, the IIA compares the relative levels of growth under the different options 1 to 5, and it's based on the data that was available at the time the assessment was undertaken. So at that time, when the IIA was undertaken, that we were anticipating up to 40,590 homes under option 3. Just to be clear, that 35,530 is correctly reflected elsewhere in the IIA. So in that sense, there is an inconsistency between table 9.1 and section 10. So the correct figure is referred to in section 10. So 10.3.1 refers to the 35,530. That is the figure that's in policy SP1. I think our view is that whilst there is a discrepancy between table 9.1 and policy SP1, the appraisal of the plan is an appraisal of the plan as submitted with the correct figure. I think as is explained in the table, there are a number of constant factors within the supply, essentially the urban supply, and then there is additional supply, flexibility, alternatives that are looked at in terms of greenbelt release under options 3, 4 and 5. So essentially there were a number of, through the further work around the housing and economic land availability assessment that was updated after the IIA work was undertaken, that resulted in some changes to the urban supply, the constants, if you like, within that table. So all the constants across all 5 options will be reduced. So the total supply under each of the 5 options is reduced consistently. So the comparative analysis stands. Just to explain why that was, which elements of supply have been lost. Some of the urban supply was reduced as a result of site appraisals undertaken as part of the site selection process, and that impacted on site suitability and developable areas. The HELA also takes account of completed sites in 2021, 2022. So those were removed from the supply in the 2022 HELA, and that's why the figure's reduced. That's the main reason. There were 2 large sites removed because they gained planning permission for office development, and 1 site at Hollinbusk in Stocksbridge was not allocated, but subsequently gained planning permission. In fact, so there were a number of reasons why that figure reduced, but essentially it was the updated HELA and the updated data and the site appraisal work that reduced the figures. But it was consistent across all 5 options.
Okay, thank you.
Yeah, I mean, I think given that what we've just been talking about in terms of the update to the IIA, we can update that table to provide show the consistent figures across all 5 options.
That would be helpful, thank you. Just moving on to appraisal of specific sites and policies. Can you just explain, for the benefit of everybody, what would the approach that you took to appraising sites, specific sites now, rather than the broad options? How was that done through the IIA, please?
Yeah, so the IIA in section 8 sets out the approach to appraising the sites, and essentially that includes a cross-reference to the site selection methodology, so that cross-reference is in paragraph 8.4.1. The site selection methodology itself, paragraphs 3.27 to 330, refer to the sustainability assessment, and that draws on the sustainability aims in the IIA. So the assessment criteria in the site selection methodology drew on the sustainability, the higher level sustainability aims, if you like. So IIA Table 8 summarises the site appraisal methodology and the 5 stages there: identification of sites, initial checks, and then a suitability assessment, availability assessment, and achievability assessment. So Appendix I then essentially just replicates the outputs of the site assessment method for each of the sites considered through that process. I don't know whether, Ian, whether you want to come in on anything there on that. Yeah, that was the process. So it's essentially a sort of replication of the site selection methodology in Appendix I.
Okay, thank you. So the detailed appraisal tables that linked through from the Annex A, the site selection methodology, it's CD56, is it? That's how you appraise the sites, and that links through to the SA criteria framework. Yeah.
Yeah.
Okay, thank you. Just for clarifying that. And did you appraise all of the sites that were identified to you at different stages through the plan process? Have they all been identified, appraised in that way?
We appraised 483 sites through the site selection methodology. I think not every site was considered to be a reasonable alternative, but all sites that in the urban area that were put forward through the call for sites or through the Regulation 18 stage were considered. The sites submitted at Regulation 19 stage by objectors have not been appraised because they're obviously that's the plan that's ultimately been submitted, unless they'd previously been submitted and considered through the site selection methodology. So in some cases we've got representations again about the same sites at the Regulation 19 stage. So the site selection methodology was published for the Regulation 19 stage in January 2023 and therefore doesn't include sites submitted after that. Most sites put forward at the Reg 19 stage are in the green belt or very small sites that are deemed too small for allocation. So small green belt sites were not appraised through that process, and it relates back to the discussions we've just been having about how small green belt sites are considered, and I think that's something we'll perhaps need to take away and consider that as part of the note in terms of how that might affect the site selection methodology as well.
Okay, so larger sites in the green belt, if there were any, that were identified through Regulation 19, were they not appraised either?
Well, for clarification, the sites that were submitted that were in the green belt at Regulation 19 are listed in CD 23, Table 1. Off the top of my head, they largely are smaller sites, not on their own, I don't think, are a strategic site size, other than if they will have been incorporated into the strategic greenbelt locations that were considered through the IIA already. Does that make sense?
So they've been considered through the, yes, so you've considered them through the IIA Greenbelt Review rather than through the site assessment.
Yeah, which obviously includes an assessment taking account of the same indicators. The indicators that have been used in the appraisal of the strategic greenbelt locations reflect indicators that are used in that element of the site selection methodology. Is that right? Yeah.
And where you appraised sites through the greenbelt methodology, was that based on the same boundaries? Were they the same sites that were submitted to you through the where sites were identified to you through the call for sites or through Reg 19 submissions, and then they were appraised through the greenbelt methodology? Were the sites appraised on the same basis, or was it a bit different in some cases?
So just to be clear, are you asking about the greenbelt review rather than the IIA?
Through the IIA.
Just go back again. Would it help just to go back a step and re-explain? Yes, I'm confused. just in terms of that
I think the original question that you asked was what happened to greenbelt sites that were sent in to us at Reg 19 stage. And I explained whether...
Can we go back one step? Can we go back and talk about the call for sites? Have you appraised all greenbelt options that were put forward to you? And then we'll talk about Regulation 19, perhaps, so, just in that order.
Greenbelt sites that came in previously through the call for sites. We've already described that they were not considered on individual basis in the site selection methodology, but a number of them form part of the strategic locations that were considered through the IIA, but not, obviously not all of them. Does that help answer the question better?
Yes, so effectively there's a whole bunch of sites out there that you're saying haven't been essayed, the smaller ones. Is that right?
Yes, if they don't form part of that strategic locations alternative, no.
And the reason that they weren't appraised was?
If they weren't part of the alternative that we were considering.
Yeah, perhaps if I can just come in. I think the strategic decision, if you like, to go with option 3 meant that subsequently it was considered unnecessary to consider smaller greenbelt sites. So we'd made the strategic decision about what the approach should be to greenbelt, and therefore it wasn't considered necessary to go back and look at the smaller greenbelt sites. It's worth saying that the greenbelt review and the addendum does look at the greenbelt purposes of the sites that were submitted through the call for sites and through the Reg 18 stage. So that the greenbelt review does consider the smaller sites in terms of purposes of greenbelt, but the SA it doesn't, unless they're in the strategic locations.
Mr. Bolton, did you want to comment on that?
Yes, I mean, to some extent you've heard my comments on this, and that these sites that were submitted do form or can form part of a reasonable alternative and need to be assessed. Just to draw your attention, you've heard clearly from the council that they've not been assessed on the basis they'd made the decision already in terms of their strategy and therefore weren't required. The council also said that some of the smaller sites were assessed because they were part of a larger strategic element, but the point is that I would like to make is that each site should be looked at on its own merits, because it may be that 2 or 3 sites in an area could be released and have a completely different impact and positive impact than a dozen sites in that area. They could have a very, very different impact on the green belt in terms of their relationship to infrastructure, etc. So they do need to be assessed separately on that basis. That's the only point I'd like to make. Thanks.
Thanks. Mr. Rose?
Thank you, ma'am. Yeah, it's interesting, and I think the council have obviously accepted that they've not appraised all the options that have been put forward. As they obviously, as per their approach, obviously they're saying they're not strategic locations. But that means quite early on the council obviously weren't considering, they came to this this 1,000 unit minimum figure in terms of growth areas. They obviously came quite early on, and that's where they appraised them. But then clearly, as we've gone through, we've evolved from the 3 options that were in the issues and options on the scoping report there, and we've evolved to these 5 options, which were presented to committee in December 2022. We then roll through this document here, which clearly has appraised those 5 options, one of which is meeting full housing need with 35% uplift, which has clearly been dismissed by the council. I note when I look at the committee paper that was presented to members in December 2022, there's no reference towards the SA and the appraisal that has been undertaken. So whether members were rightly informed or not as that, because clearly when you go through these options in table 10.1 and you compare option 3, proposed plan, to option 5 here, there's quite a range. There's a few question marks on option 5, which go from negative to major positive, but the major positives outweigh the negatives. When you take a balanced view, planning judgment, whatever you want to call it, there's clearly some major positives here, which when you get through to the conclusion, even on option 4, which is the strategic locations, which the council have clearly appraised those sites, not the smaller sites, they've appraised the strategic locations, and they've clearly highlighted that there's some quite significant positive effects on option 4, which is, but the ones that have outweighed them are things like, with an increase in greenbelt release, negative effects upon soil and land and landscape. But clearly they can all be mitigated. I appreciate that's not the role of the IIA or the SA, whatever you want to call it today. But there's clearly some resolution and mitigation here, which I appreciate will come back to the wider picture in terms of housing need versus housing requirement versus employment, etc. But there's some significant positive effects here, which haven't really been considered, but equally we're also talking about these other alternatives in terms of the smaller sites, whether they fit into option 5 or not, but equally they haven't actually looked at them. We're directed towards the site selection methodology. Appreciate it's a separate process, but when I go to the site selection methodology, it's opened up an option here in terms of the appendices, and I'm looking at CD 56, I don't know if that's the right one, but you go through the appendices to that, it hasn't got all the sites in that have actually been put forward, because the sites that we've put forward aren't included in there. It seems to be the only ones that are allocated, and the date on that is January 2023. So when you come back to how they've actually appraised or considered sites, considered reasonable alternatives, in my view, rightly or wrongly, I think the way that they've written this, and they've written the site selection methodology, appreciate that, but there is an overlap between them, they've actually been done post-decision. And it's post, but then you can't actually then fully aware and fully cognizant actually think, well, actually, what is the right approach? What's been presented to members? That's the decision they've made, and we've mentioned before, this is a politicised approach which doesn't reflect the evidence. And the evidence here clearly points towards higher growth, higher employment, higher housing to meet the needs. The needs of Sheffield and the needs of the region and the needs of the country. Thank you, Mum.
Thank you. Firstly, can you just comment on whether the members were aware of the IIA work that you did?
The IIA. The consultation concluded at that point, yeah. Ma'am, we're going to just get a reference to you. Sorry, we were just looking for the reference, but it's incorrect to say that members in determining to submit the plan for examination were not aware. It's a listed document on the committee report, and consultation had concluded at that point. So we'll find the reference for you, but I'm afraid that's not correct. Second...
Jump in there, sorry, Miss Reid. When I'm looking at it, it says background papers here on 14th December 2022, it lists down as background papers. All it lists is report to the Co-op Exec, Sheffield Local Plan Spatial Options, Sheffield Statement of Community Involvement, July 2020, Sheffield Local Development Scheme, 21st of October 2021. And the only thing that's appended is some sort of health equality.
Sorry, we're looking at something different, Mr. Rose, because I'm looking at something that says IIA. So if you just, I mean, we can just find it now, but if you just give us a moment, I'll see if I can get the reference, if it would assist. So it's exam 17, sorry. So it's paragraph 4.3.4, exam 17. Sorry, there's sort of cursor that's flicking around on the screen, so I can't actually read what it is. Just a second. Yeah, proposed list of submission documents, and it's one of the listed documents.
Okay, thank you. Can I just jump in there? Because under 4.3.4, when it talks about the integrated impact assessment, it actually says Sheffield Plan Integrated Impacts and Scoping Report 2020. Sheffield Plan Interim Integrated Impacts Assessment, Main Report 2020. So that's the earlier version, the one that went to the scoping. Sustainability page or SCA assessment, all it says is integrated impact assessment, but we've just been told that that's the date on this report is December 2022. So it says it's proposed list of submissions, but were these all available to members? Because under background papers, it's not listed.
Do you want to come back to us? Yeah, that's okay, that's fine. We'll come after lunch. Okay, thank you. So, just go back to the sites and how they were appraised. So you appraised the sites that were submitted at Reg 19 stage. Were they appraised through the site selection process?
No, because they were brought to our attention after the site selection process had been carried out, because that was carried out prior to Reg 19.
Okay, so as part of the kind of, you're looking at additional work that might need to be done on the IIA. Can you just have a look at what sites were appraised and whether there's any sites that need to be appraised through the site appraisal methodology, through the IIA, that haven't been?
In terms of those that came forward through the Reg 19 consultation, yeah.
And any that have been you've been made aware of more recently as well.
Yeah, I just need to clarify that which of those sites that would be. So, as Simon, as Mr. Vincent set out a moment ago, the sites that were introduced to us at Reg 19, some had previously been proposed, but of those sites, they were all either in the Greenbelt, which we've already discussed the approach to that, or they were sites, small urban sites, too small to allocate.
Okay, so if you can set out the approach to that then as part of the kind of where we can then reflect on it.
Sorry, I think I understand what's being asked for. I think what you're asking us to do is to check whether there were any additional sites that came forward that, had they come forward at an earlier stage, would have been included in the assessment that was undertaken, applying the parameters that were
applied at that point in time, essentially. So on a like-for-like basis, were there any additional ones that would have come in had we been aware of them before?
I think there's also the issue of how you dealt with the sites that were put forward through the call for sites process as well, because obviously our discussion earlier this morning, we were talking about adding in an essay on this alternative option, this extra option of a strategic sort of dispersal strategy effectively, rather than looking at strategic locations in the Greenbelt. Well, as soon as you sort of go down that route, then it obviously does. And I don't think we had appreciated that you hadn't appraised all of those individual Greenbelt sites. We hadn't picked up on that fully. Well, that's why we had the question in the agenda. We weren't sure. So you've confirmed that that hasn't taken place. Now that obviously I think does actually raise questions about, is there then a need to actually do SA on all of those site options if you're going to have a cohesive sustainability appraisal that ticks all the boxes? So I think from, so I'm talking over Rosie here, but like from our perspective, we would definitely want the council to look at that issue, take that away, because it does raise, I think it's a really important point. And obviously, it's supposed to inform policy development, but we're not sitting here saying everything you've done is wrong. What we're just saying is that actually we need to look at all reasonable alternatives, and some of those sites might need to be appraised. The Regulation 19 sites, so sites that are put forward, Regulation 19 stage and after, it is quite normal then for inspectors to say, can you just do SA on those, put it in a separate document, doesn't have to sit with an addendum, I think a separate document where it's just really clear that all of those sites that have been put forward have been appraised against the criteria, and you've got that evidence base. So that would be standard for us to ask.
Just to be clear in terms of the reason that we're here and that wasn't done in terms of the smaller sites is obviously, I think, in terms of using the IIA as an iterative process, it having been concluded that those were the reasonable alternatives in terms of the strategic growth options that were going to be considered. If sites didn't fall within that, then they weren't considered. But we do understand the point that you're raising. If we're going to be considering an additional reasonable alternative, what flows from that in respect of extra work? So perhaps if we sort of look at we'll look at that in terms of the note and what we're proposing to do, and that can be included, and perhaps we could have a further discussion at that point.
Mr Bolton, did you have a comment on?
Thank you. I think we've got to where I was wanting to get to, in that the sites which have been submitted that don't conform to the strategy, i.e. it requires Greenbelt release, were just put to one side immediately. They weren't assessed in any formal way. So we're now doing that with all sites. That's great. Thank you very much.
Okay, thank you. And as the other question that I had about sites that are allocated, the sites that have already got planning permission but are allocated, have they been assessed as well through the site selection methodology?
Yes, they were assessed through the site selection methodology. Yes, they were considered through the site selection methodology. Obviously, just for clarity, some of them have gained planning permission since that point.
Just to be clear on that, so the sites were assessed through the site selection methodology. One part of the site selection methodology was a suitability assessment. Sites with planning permission didn't have that stage of checks done because we deemed that the planning application had already assessed the suitability of the site for the proposed use through the application process.
Okay, thanks. Thank you for clarifying that. So the only other question that I quickly wanted to ask was about the approach to policies. Can you just explain the sort of whole plan approach to assessing other policies? Because you've explained in, I think it's paragraph 10.1.2, that there wasn't any, you didn't consider any other reasonable alternatives when necessary for policies. But if you could perhaps just explain the approach that you've taken there and why. Thank you.
Yeah, I've got some references, so let me just find them. So yeah, as you pointed out then, Section 10 sets out the methodology for praising the plan. And when I say praising the plan, that's all the policies within the plan. So it's taken as a whole. And the reason we do that is because obviously policies interact with one another, and what we're trying to find out is the significant effects of the plan as a whole rather than its individual components, because actually a lot of them cancel each other out sometimes, mitigate each other. So that the approach to appraising the plan is in terms of all the policies considered together, and we've done that for loads of different SA reports, and that seems to be an approach that's kind of accepted. In terms of considering sustainability, equality and health impacts, the equality and health impacts, they're kind of considered throughout multiple objectives. They were incorporated, like integrated into the appraisal framework. But if you look at Section 10.4, that's an appraisal against a specific health topic. And then again, equality is reflected as a cross-cutting issue. So it's within SA Objective 4, 5, 1 and 2. And if I just point you towards paragraph 3.4 on page 8 of the report, and that kind of sets out the approach in terms of integration of those different elements throughout the SA framework. Does that answer your question?
Yeah, so as you developed the policies through the plan, how were any mitigation measures for policies identified? Or did you look at that in terms of sort of, and how the policies work together, and whether there was any conflicts between them? Was that something that you looked at through the SA?
Yeah, we did that, yeah. I mean, at issues and options stage, the council undertook the appraisal and they looked at mitigation at that stage as well. So I think appraisal was undertaken on an iterative basis and to feed into the policies as they developed. The appraisal that's set out in the plan is of the final policies that are within the plan, and then any remaining mitigation measures that we suggested are within the report on page... section 11, which is page 110. So that sets out the mitigation and enhancement measures that were considered at the different stages and how they fed into the kind of final policies. So there's a couple of recommendations in the report that have not been resolved yet, but that they could be, the idea is that they'd be picked up through the modifications process if necessary, if the council deemed that it was necessary to do that. They're at 11.1.2 on page 110.
Okay, thank you. Thank you. So that's all the questions that I had in terms of the IIA. Obviously, there's a number of action points. Well, and so we're going to come back and look at this again. in terms of the note, and yeah, further discussion as necessary on that. So, but I haven't got anything further to add unless has anybody else got any further questions on or points on the IIA? No, in which case we can. Do you want to break for lunch?
Yes,
Thank you, Rosie. Yes, we were hoping to get through item 5, but I think looking at the timing, it's probably best to take a break now for lunch. So I was just going to ask the council actually how long you would need for lunch, 45 minutes or longer?
45 minutes is fine.
Yeah, 45 minutes I was going to suggest. So yeah, that takes us then to 1:30. Sorry, I'm trying to look at my watch. Yeah, so 1:30 if we'll meet back then. Okay, thank you. Okay, good afternoon everyone. We'll resume with item 5 on the agenda, which is the Habitats Regulations Assessment. I believe that we're being joined by a representative from the Peak District National Park Authority. Is that person in the room?
We have, but I think he's just left for a moment. I just saw him on the way out.
Yeah, he's here. He's here.
Oh, yeah. Okay. I've obviously timed that. I should have taken my chances and I just done it when he was here and gone for it, but okay. Well, he's not due on, obviously. I've got an item to talk about some of Natural England's comments first, so obviously when he arrives then we can get to his item in due course. Okay, so the first bullet point on the agenda, it's the issue of the disagreement between the Council and Natural England, the outstanding area of disagreement as set out in the Statement of Common Ground. But obviously, Natural England are unable to attend today and they've submitted a letter, in a statement in lieu of that. What it says in the statement appears to slightly change the agenda and possibly change the HRA and possibly change the Statement of Common Ground. Obviously, that's my reading of it. It seems to be saying that there may not be any likely significant effects on designated sites, but that further assessment work is needed by the Council. I think two parts of that, potentially reappraising pollution, taking account of the separation distance, and then secondly, appraising in combination effects once that first task has been done. That's my reading of the letter, but I'd very much obviously like to get the Council's viewpoint on that letter and whether you have agreed to the work already. You may have done so.
Yes, hopefully I can provide some helpful clarification on this. So, we've been in continuing discussion with Natural England, and their letter reflects the discussions we've been having with them. So I think their conclusion was that the plan on its own is not likely to have any significant effect in terms of air pollution on the South Pennine Moors SAC. I think where they were uncertain and where they've asked us to provide further information was regarding the in combination effect with other local plans. So we've been seeking some clarification from our transport consultants who have undertaken the transport assessment to understand how the AADT figures were calculated and what account was taken of other local plans. From advice I've received from them just in the last day or so, that they are saying that the transport assessment does factor in other local plans insofar as it takes account of the national trip end model, so it factors in growth from other areas as well. I think we need to discuss that further with Natural England to check that they're content with that, but it does seem as though it is factored in. If that's the case, then the in combination effects are not significant either. That would be our reading of it. But we just need to agree that with Natural England. So we would aim to agree an addendum to the Statement of Common Ground once that's been clarified. And I'm hoping that Natural England will say at that point that because the AADT figures are so far below the 1,000 trip increase, the 1,000 trips increase, I think the highest figure is about 339, I think, from memory, in the HRA. It's in the table in the back, I think. So that's sort of where we are on that one. And I think I don't know whether, Stuart, you may want to just comment on this issue about the 200 metres distance from the road.
Yes, certainly. One of the issues that we're discussing with Natural England is whether the separation from the road to the actual sensitive habitats within the site is such that even if we were to trigger a potentially likely significant effect by tripping over that 1,000 ADT, whether we would actually have a significant effect on the integrity of the site, because that obviously is the test, not whether there is any increase in air pollution, but whether that air pollution follows the source pathway receptor model of actually landing on something that can be damaged by that increase, and therefore there is a potential impact on the actual integrity of the site. And that's where we'd look at the separation between the source being the road and the actual sensitive habitats in terms of distance, and do an ecological appraisal with our air quality colleagues to determine whether there is actually something that's going to occur. seems vanishingly unlikely given the very low numbers of additional trips that are predicted at the moment.
So just to confirm then, because obviously I don't think I had picked up on that in the HRA work, but obviously Natural England have raised the issue about the separation distance. So you can confirm that you didn't take account of the distance, that you just did the straight appraisal just based on one figure. That's correct then, is it?
So yeah, at the moment the HRA is based on a very precautionary approach. So it's taking the highest figure that's being registered by the air quality model, which is effectively that at roadside, and then saying, well, if that's, if you imagine a road that's running directly through an SAC, then that would be important. Here, in this, particular circumstance, we do have generally a much greater separation between source and receptor, and therefore you would be much less likely to have a significant effect on the, on the integrity of the site.
And what is the sort of general setback distance then of the SPA SAC from the roads then?
Apologies, Inspector, I don't know off the top of my head, but we can find out and get you an answer.
No doubt, I'm sure it will come out of the work, the additional work that you're talking about anyway, so I can leave that for now. Okay, thank you for clarifying that. So we obviously have, we've been joined now by the representatives from Peak District National Park Authority. So I was going to get their input just if they had any comments on Natural England's letter. So perhaps it's just a good time if you'd like to introduce yourselves, please.
Hello, yes, so I'm Brian Taylor. I'm the Head of Planning at the Peak District National Park Authority.
Thank you.
And Rodri Thomas, I'm the Land and Nature Team Manager for the National Park Authority.
Okay, thank you very much. And I'm Katie Charles, so I'll be dealing with this item, obviously. You obviously missed our introduction this morning. I think the only important thing I'd say to you is just if you remember to turn off mobile phones or put them on silent. But anyway, so in terms of Natural England's letter, did the Peak District National Park have any comments that you'd wish to make on the contents of that letter, which obviously changes their position, I think, considerably in terms of the statement of common ground?
Yeah, just initially, I think they acknowledge that a discussion can take place between the planning authorities, and we're just thankful that some good engagement has happened very quickly on that basis. We think that's a really positive basis. So, I would leave the evidence behind that to Rodri, but I think we just say initially that we've been very grateful for that positive engagement on that issue. So, which I think is where Natural England leave it in that respect, because they're saying actually they won't take a view on the difference between their initial view and where the evidence might take us. So I think it's now in our hands.
Thank you. Mr. Thomas?
Yeah, thank you. Just to add to that, I think on the air pollution side of things, we don't have any particular comments in relation to that. We leave that issue to Natural England. Our principal concern is around the sort of recreational pressure and the potential increase in recreational pressure and the impacts of that. And as Brian said, we have been in negotiation with, in liaison with Sheffield City Council over that, and I think we're reaching some common ground on that, which we can go into further.
Okay, we'll obviously come to that item in due course on the agenda. But so in terms of then where we're at with this further HRA work and updated statement of common ground, I think obviously if you could add those then to the running list, the action list of 2 documents that would need to be produced. I'm assuming that it would be, is it an addendum to the HRA, a further addendum? Is that what you're proposing to do? Yeah. So that would probably then need to be consulted on at some point, and obviously try and deal with it obviously in writing and see what written comments come back. Okay, I've got no more questions on that aspect. So if we move on then to the concerns of the Peak District National Park Authority. Obviously, this is a late representation made by the authority, and you've raised some concerns, and it's to do, as you said, it's the impact of recreational pressure on the South Pennines Moorsack and the Peak District Moors SPA. So I would like to understand your concerns that you've raised, and discuss what particular changes you might be seeking, if you are still seeking them. You may have obviously negotiated a compromise position, but obviously please tell me. And obviously looking for the council's views on any objections raised. So the first objection you raised is obviously about the 7-kilometre zone of influence. Did you want to outline concerns or just tell me what recent work has been undertaken?
Thank you. Yes, so Natural England, our understanding is that Natural England initially recommended a 15-kilometre zone of influence, and subsequently that's been reduced to 7 kilometres with some evidence based on Bradford in particular around that. I think our concerns are that from a practical point of view, in terms of our experience in the Peak District, and I have to say there's limited amount of visitor survey data. It's quite difficult to come across. We have some visitor data for the Peak District, but certainly based on our experience, 7 kilometres feels that it's a very short distance in terms of the distance that visitors come to from the Peak District. We've had some discussion with Sheffield City Council over this. There's a further piece of evidence which has come to light recently, recent publication, which both ourselves and Sheffield City Council acknowledge as a new piece of evidence. I hope I'm not putting words into your mouth there. And that's a recent report by Natural England, which I refer to in my written statement, under the zones of influence. So it's report NEER 025, the influence of recreational activity on upland ecosystems in the UK. And that is specifically looking at the potential impact of recreation as a result of strategic development in the South Pennines on the South Pennine Moors European sites of the SPA and the SAC. So I think it's particularly pertinent to the local plan here. And the findings of that really, it recognises that the standard in terms of Natural England don't have any national guidance in terms of setting zones of influence, but this recognises that the accepted practice has become using the 75th percentile as a measure of that. So that's the distance within which 75% of your visitors come. And the findings from that report, which was published after Natural England provided their comments to Sheffield City Council originally, the findings of that report were that that 75th percentile is about 24.4 kilometres, in fact, for the South Pennines. It does recognise that there is. It recognises that really there's further work needed to be done to estimate, what the impact is. But our view is that that's the best available evidence at the moment in terms of zones of influence. So if anything, that's suggesting more than the original 15 kilometres. And we're in discussion with Sheffield City Council about how we tackle that and how we deal with that.
So before I go to the council to get their view, could you just clarify for me then, you say that there's a specific figure for the South Pennines. What specific area does that cover? Is it the national park itself or the SPA?
So my understanding is that it covers the SPA. It covers both phases of the SPA. So the SPA was designated in 2 stages. The first stage that covers the moorlands essentially within the Peak District National Park, and then the second phase, which is the area of the South Pennines north of the National Park, and my understanding is the report covers both of those.
Thank you for that. Can I get the Council's response, please, and your views on this study and what it's saying?
Yes, I think we obviously recognise that this report has now been published or has been sent to both the National Park Authority and the Council by Natural England, and this is new evidence that we think would justify a further addendum to the HRA. We note that Natural England have confirmed in their statement submitted to the inspectors on Friday that you've referred to that the new evidence does not change the advice that they would give and really leaves it to the local authorities to agree on appropriate zone of influence. So I think that's something we will need to talk to the National Park Authority about. Obviously, if it's a 24.4 kilometre zone of influence, that would effectively cover the whole of Sheffield district, would fall within that zone of influence. In principle, the Council and the National Park Authority, we're happy to work together, taking further advice from Natural England as appropriate. We've talked about producing a mitigation delivery plan, and Mr Thomas has helpfully provided some suggestions on the scope of that, which we could provide to the inspectors. I think that's something we're broadly happy with, with what that covers. I think we would need to see some costing of the mitigation measures that are put forward there. That does suggest that obviously there would be a cost to those mitigation measures, and it may be necessary to seek developer contributions towards any identified mitigation measures. But we do need to have agreement that the level of any contribution should be proportionate. Must not undermine the viability of development in Sheffield. But we would be happy to commit to work with the Peak Park and other local authorities as appropriate to produce a supplementary planning document on setting out the mechanism for how any developer contributions might be made and the level of those contributions. Clearly, if we are talking about a 24.4 kilometre zone of influence, that potentially brings in a large number of other local authorities as potentially having an impact on the South Pennine Moors SAC and SPA. So I think there would need to be some further discussions around how that SPD, whether it's which authorities would potentially need to look at something similar, which is perhaps an additional complication. But we will work with the National Park Authority as quickly and as collaboratively as possible to seek to resolve the matter within the examination timescales, and to provide a further statement of common ground as soon as possible to assist the inspectors.
Okay, I appreciate it's probably early days then, isn't it, in terms of looking at the exact mitigation measures, but at the moment in your plan, I think you have policy NC15, don't you, which talks about, well, it's not talking specifically, obviously, about these habitats, but it's talking about generally sort of providing open space in larger developments and smaller developments. So would that be where you're probably looking for some changes then to the policy itself?
Possibly also policy GS5, which is the policy that deals with biodiversity, because I think we would need to highlight there that mitigation is likely to be needed for the South Pennine Moors SAC, and that might also then lead on to an amendment on to policy DC1, developer contributions policy, that would need to highlight the developer contributions that would be required towards the South Pennine Moors SAC.
Okay, thank you for that. Sorry, Mr. Taylor?
Yeah, thank you for the suggestions on the areas of policy. I mean, another might be worth looking at green infrastructure, because it's not just about the habitat protection themselves, which is already afforded protection by virtue of the park and the international designations, but it's this relationship that we're talking about from new growth and the people using those areas and visiting. So, in some ways, I think the connection might be about enhanced linkage and the maintenance of those, and the pressure on those pieces of green infrastructure that allow people to move out of these kind of green fingers from Sheffield out into the countryside those are the areas where we suddenly get contact with these areas. So just a suggestion, that might be another area to look at in terms of policy, just the green infrastructure.
Okay, thank you. And then, obviously, I appreciate this is probably quite a bit of work, isn't it? If you're having to talk to other authorities, have you sort of got any timescales in mind? Not pressing you on that, but it just might be useful to know a vague timescale.
I think we'll have to give that a little bit more thought, perhaps come back to you on that, if that's all right. Thank you.
Okay, thank you. So obviously I did have quite a few questions for the Peak District National Park on your previous representations, but I'm assuming that obviously whilst this work takes place, then you'll have to then take a view, I think, in the outcomes of that, won't you? Is that correct?
Yes, I think we've very much welcomed the discussion we've had so far with Sheffield City Council. I think we feel confident going forward that we can reach common ground. Mr Vincent has kindly offered to draft a revised statement of common ground to reflect that. So I think our principal concerns were around the zone of influence, around the appropriateness and the effectiveness of the mitigation measures, and around the deliverability of the proposed mitigation measures. And I think in all three areas we feel positive in terms of finding a way forward with Sheffield City Council on that.
Thank you for confirming that. I think that probably concludes my questions then on this issue for now, but obviously I've got it down as 2 action points to do a updated HRA addendum and a revised statement of common ground. So if you could add those both to the running list. Thank you. Was there anything the council wanted to finally say on this issue? No? Okay. Any final comments from the Peak District?
Yeah, just to point out that there is perhaps a useful precedent in the New Forest, where a collection of local authorities within the zone of influence have addressed a very similar problem in the New Forest, the recreational pressure on the European sites, on the internationally important sites in the New Forest, and a costed mitigation plan has been produced. That was it. So some of the different local plans were at different stages in that. So some had already been approved. Others, it was pre. My understanding is others were sort of pre the local plan. But there is a useful precedent there, I think, in terms of that sort of common approach, and that's something we're investigating and talking to Sheffield City Council about.
Thank you very much. Yes, Mr Taylor.
Yeah, just a final thing for me. It was in its wider context about the role of the National Park and the different kind of legislation that we have. I mean, one of the reasons that we thought it was a good idea to take the opportunity of which arose through the Statement of Common Ground and the issues about the HRA was changes to the National Park legislation in the Levelling Up and Regeneration Act, which has strengthened the duty for relevant public bodies to have regard to national park purposes. And the closeness that Sheffield has to the Peak District in that respect, covering such a large area of its city area, made that more relevant to us, I think. We have a separate requirement to produce a document called the National Park Management Plan. All national parks produce these in addition to the planning process. And that draws in local councils as a key partner to the delivery of those purposes. So, you know, it's just catching that different context for us as a national park and wanting to find those opportunities to work together. Thank you.
Thank you very much. Okay, I don't have any further questions then, so that concludes item 5, and we'll move on to item 6, which my colleague David Troy is leading on. Just to say that there's no need for you to remain, but thank you very much for coming along.
Okay, thanks. So yeah, just a few of the matters basically just to cover. I've sort of covered most of them, I think, in the agenda really. Just wanted to go through a few of the points that arose from the representations. In terms of just feeding out from the question on strategic policies, is there a strategic employment policy in the plan equivalent to the strategic housing policy H1? If not, why not?
No, there isn't an equivalent policy. I think our view was that this is adequately covered in policies SP1 and SP3 alongside the relevant sub-area policies. And I think there was no need to repeat what is being said in those policies in a separate strategic employment policy. So policy SP1B sets out the hectares of employment land required per year. Policy SP1D deals with the priority locations for economic growth within the central sub-area and the innovation district, helping meet the objectives of the South Yorkshire Mayoral Combined Authority Strategic Economic Plan. SP1F deals with new retail and leisure floor space to be focused within identified town centres, which are the city centre along with the 17 district centres and identified local centres. So I think that our feeling was that it was slightly different to the situation with housing, where the MPPF requires a trajectory to be set out and local plans are required to identify a deliverable and, if possible, developable supply. The situation is a little different with employment land, and hence that's the reason for just a single policy on housing.
Okay, Mr. Rose.
Thank you, sir. Yeah, I think this is our point, sir, around employment. And obviously, as you've seen from our position and our statements, we obviously take a slightly different view. Obviously, if we look at Chapter 6 of the September 23 NPPF, obviously it's building a strong and competitive economy. It sets out, obviously, that the plan should create the conditions in which businesses can invest, expand and adapt. Obviously, I don't need to repeat. Obviously, I'd direct you to paragraph 82, which is what planning policies should do, which is sets out a clear vision and strategy which positively and practically encourage sustainable economic growth. Having regard to ... set criteria for identifying strategic sites for local and inward investment to match the strategy and meet anticipated needs over the planned period. Part C is obviously seek to address potential barriers to investment such as inadequate infrastructure services or housing or poor environment, and D, be flexible to accommodate the needs not anticipated in the plan, allow for new and flexible working practices, etc. And then obviously it moves on to recognising and addressing specific locational requirements, etc., etc. So obviously, if we look at the Sheffield Plan, yes, policy SP1, overall growth plan, within there sets out the number of hectares. We'll leave whether we agree or disagree with those at the moment in SP1B and sets out some other points through SP1. But then if we have a look at H1, which is the equivalent in housing, there's an entire chapter on housing. Policy H1, scale and supply of new housing. The plan is silent on employment. The plan doesn't even have anything similar to this in terms of housing. It doesn't have a chapter in terms of how it's going to deliver economic development and growth. The plan doesn't include anything that talks about investment. It doesn't talk about employment. It's clearly something that has been set to one side and merged into all other aspects of the plan. So there's nothing clear, coherent, or effective around how it's actually seeking to address employment. And that's what we're looking at here, isn't it? Whether the plan is effective, whether it's justified, whether it's sound. And I think because it hasn't got that, and you look at all other plans around the country, they all have employment as a, in terms of a policy. They all talk about how they're going to deliver employment, how they're going to address any windfall employment, how they've got criteria-based policies around that. We just look at some recent ones adopted in the region, such as Wakefield. They've all got employment policies within them. The plan here doesn't have an employment chapter. It doesn't have an employment policy. It's only got those few bullet points within SP1. So I think, from my point of view, I think it's devoid on that, it's silent on that, it doesn't look at how it's addressing the needs for employment at large. Thank you.
Thanks. You seem to have two mics, so it's fine. They seem to be joined. Could I just get the council just to respond to just this particular point, really, about whether they, Mr. Rose's comments about whether there is an effective framework, strategic framework within the plan as you've laid out. You've obviously it's set out in various parts, SP1 and the various sub areas. So just get your comments in response to Mr. Rose.
Yeah, I think we're feeling that perhaps less is more in this case. That we don't need to say things twice. We think there's sufficient coverage of the plan. Very clearly sets out the quantum of employment land that's needed, and it identifies the locations where we'd expect new employment development to take place in both SP1 in very broad terms, but also in the sub-area policies as well. And I don't think we just didn't feel that it, for the sake of having an employment policy, it was necessary. It was just adding words and length to the plan, really, essentially. We're happy to, if the inspectors have suggestions on what additional...
Sorry.
Sorry.
Can I just come in? I mean, it's obviously a case of quality rather than quantity, and if one looks at the wording of paragraph 82 of the framework, it's talking about encouraging sustainable economic growth. The council says that SP1 does that. There are a number of sub-paragraphs within it. One of them is identifying strategic sites. Well, it clearly does that. Paragraph C refers to the site allocations, including those for economic development and mixed uses. It's talking about barriers to investment, infrastructure, services, housing or poor environment. Obviously, we're going to have the infrastructure sections, but we can see in, for example, Part D, there's specific reference there to AMID, and in E, coordinated investment in the broad locations for growth to enable these areas to transition from employment uses to housing. That one, so it's the other side of the coin. But, it's clear that these issues have been given consideration and are expressed through policy SP1. Just looking through this, and also the reasoned explanation just on economic growth, of course, pages 22, appreciate these aren't policies of the plan, but 22 to 23 provide the context for all of that and how that fits within the paragraph that's just been referred to.
Ms. Rose, you want to just come back yet?
Yes, sir. Just responding, sir, because clearly you're being directed to paragraphs such as paragraph C, STEM C, which talks about 372 site allocations, including 297 for housing, 52 for economic development. You're being directed to the D, which talks about where the strategic employment allocations are. Then E, which looks at broad locations for growth, obviously there for housing. New retail talks about travelling show people and gypsies. But there, similarly, where it's relevant for housing, they're in policy H1 as well. So I don't think you can say, oh, that's all right, we've covered it in SP1B, therefore we don't need a separate employment policy for strategic direction of growth. How we're actually going to deliver that when the title of the topic for housing is housing growth and housing land supply, policy H1 scale and supply of new housing, and then it goes through those and covers the same issues that are in SP1B but in slightly more detail. I don't think we have the equivalent. Actually, the council have accepted they don't have the equivalent on employment, and therefore it's been treated as a sort of a second cousin, for whatever better phrase, really. It's not actually addressed explicitly and specifically as the NPPF directs, and therefore I think it's not in accordance with the NPPF in that regard, because there should be a strategic direction setting a clear economic vision and strategy, and because it doesn't do that, and it's silent on that, then I don't think it actually addresses that.
Okay, thank you, Ms. Rose. Got anything further to add at this stage? I think you've covered, I think I understand the council's comments on this particular point. So
No, sir, only to say
saying something twice doesn't make it a better point than saying it once, and we're content that the issues are covered in substance in policy SP1 for the reasons that have been set out.
Thanks for those contributions. So just another point, just clarification in response to MIQ 1.14, which is on the strategic policies in relation to the relevant strategic policy plan. The Council's response in their hearing statement states that the strategic policies are identified in the contents page of Part 1 of the plan, or CCD01 marked with the triangular symbols. Does that also apply to Part 2 as well? Because I think the triangular symbols also appear in Part 2, which I presume denote strategic policies in Part 2. So it's just a point of clarification. My understanding is that they are both Part 1 and Part 2 strategic policies that somebody needs to refer to in terms of the context of the national policy.
Yes, the intention is that wherever the triangle appears, that is a strategic policy.
Yeah, I suppose following on from that, really, I'd jump into the response to your response to MIQ 1.16 on neighbourhood plans. It's just this point about where the triangular symbols apply. Obviously, I haven't discussed the issue there. That obviously there seems to be a bit of ambiguity in the response that the relevant strategic policies in the plan within the plan should be in general conformity with the contents page of Part 1. It doesn't refer to Part 2. It's just a sort of I just wanted just to reflect on that, just in terms of whether the final sentence of paragraph 1.28 of Part 1 of the plan, which sets out the roles, obviously is important that for a neighbourhood plan they must know what the strategic policies are, and I just want to be absolutely sure that if we're content with just the paragraph 1.28 in the plan, whether that final sentence, which I think just says strategic policies in the Sheffield Plan are identified on the contents page, is just that your response only refers to Part 1, your hearing response.
Yeah, we just suggest an amendment there. I think that's just an oversight, really, and we just need to refer to Part 2 as well. That could be a minor. Could that be a minor?
No, it'd be useful if it was put in as a amendment. I mean, my suggestion in that last sentence is you put strategic policies, parts 1 or 2, the Sheffield Plan are identified in the contents pages, or something along that line. So, yeah, I think it's just useful as just that it's absolutely clear where the strategic policies are that neighbourhood plans need to refer to. Thank you. Yeah, that would be an action point. Thank you. Yeah. Need to go back to just in terms of the response to the council's questions on the 15-year time frame for the minimum time frame from adoption. In the council's response, obviously a matter 1, the council accept that the strategic policies will not have a minimum time period of 15 years at adoption, consistent with paragraph 22 of the framework. I suppose how do they consider this should be addressed?
Yeah, we accept that it's not ideal that it's not technically in accordance with paragraph 22 of the framework, and we've asked perhaps the inspectors take a pragmatic approach on this issue, recognising the benefits of getting an adopted local plan in place. We would consider an approach that makes a modification to the policy to indicate the plan will seek to enable the required number of homes with supporting text that then clarifies the developable supply would be delivered over a 15-year plan period to 2039-40.
Yes, I think my notes just say what Simon's just set out, but as we understand it, we consider that there could be a potential approach where we modify the policy that seeks to enable the number of homes that reflects an extended plan period to 2039-40. That would be a full 15-year period. And then the supporting text then clarifies what the developable supply is. That would enable us to satisfy the requirement for a 15-year plan period to 2039-40, whilst being clear in the supporting text that what the position with developable supply at the current time is. What that provides then is the opportunity to refresh understanding of that supply, potentially through plan review, which we would obviously also commit to. Yes. Sorry, just for clarification, that's an approach that we understand is being taken by Wirral Council in their examination, which is being taken forward as a proposed modification.
Just so I'm clear, whereabouts in the plan you were thinking of putting this in the supporting text, just so I'm understanding what...
That would be the supporting text to SP1. It might also need to reflect, I haven't got it open right now, it also need to be reflected potentially in a change to the supporting text of H1. Was it that the figure is carried forward from SP1 to H1?
Okay, Mr. Bolton, you've got some comments on this, thank you.
Yes, just on this point about plan period and our experience with other local plans. The requirement in the MPPF is for sites to be identified where possible for 15-year plan period. You will have ample opportunity tomorrow and today and their other sessions to know that there are identifiable sites out there to meet a 15-year period. And the strategy being pursued by the City Council in terms of broad areas of development and indeed what's just being suggested now does not meet that guidance. In those situations, Welland, Hatfield and Bedford and Central Bedford have adopted a policy, the wording of which I can provide to you, which basically requires an immediate review of the plan in order to identify the sites required to meet the requirement for the next 15 years. And if it does not do so, then the plan falls, if you like, very, very quickly. In other words, fails to be an up-to-date plan. That's been accepted by other inspectors and really is what needs to be done here. I mean, this is a large city. It needs to take its share and provide for the level of development. It's capable of doing so. It's just decided not to. And I think you need to hold them to account. And if you are going to let them off, which I suggest you don't, then an early review policy is absolutely essential.
The Council want to just come back on that point and the issues raised. Thank you.
Yes, just briefly, I think referring back to the framework at paragraph 68, the second part of that, part B, specifically refers to, where possible, identifying land for years 11 to 15 of the plan. And I think what's really critical here, and which no doubt we'll get into over the next few days as we look at housing delivery and also the spatial strategy, is that we are a large urban authority, and with the factors in mind that Simon set out in his introduction around excuse me, the need to respond to the climate emergency and provide a sustainable form of growth for this urban area, we need to put in place a plan that provides support for our urban regeneration strategy to work, to get off the ground, well, not to get off the ground because it's already been delivered out there, but to continue to work to build the best urban strategy that we can, and to sort of take Mr. Bolton upon his point that there are alternatives out there. I don't think we would dispute that. We've already talked this morning about the IIA and the fact that there are strategic locations we could consider for expansion of the city into the Greenbelt. But what we're focusing here is a brownfield first regeneration policy, which we feel provides the most strategic, sustainable growth option for our city. And the proposed, well, the potential modification that I just noted to you would enable us to give the opportunity for this plan to take that forward without being sort of sidelined by going into alternative mechanisms for delivery.
Okay, thanks very much. Gives me an opportunity to consider. Mr. Bolton? No? Okay. Mr. Rose, have you got a comment you wish to make? Yeah.
Thank you, sir. Yeah, just a couple of small points. Obviously, we concur that the plan should be 15 years from the point of adoption. That's what the MPPF says, and that's what we should do. So, clearly, the vision and objectives, everything should be set out again. And I just keep coming back to it because obviously I'm here. And just in response to how the remedy or how to address the 15 years, again, came back to housing and how we address that in policy H1 and how that's addressed in terms of housing subtext and supporting text and how that would address housing in policy SP1. Clearly, housing and employment need to be looked at in balance, that it needs to be sustainable, it needs to be economic growth. Come back to again around chapter 6 and how I think this plan is deficient in terms of addressing the NPPF in chapter 6. Back again to the strategic employment policy and how this plan looks strategically in terms of employment and growth, jobs and homes and everything that comes together. So if the plan is to look forward for another year or two, obviously we'll have to look at the changes in the addendums that have already just been talked about today and how that impacts on the local plan process. But clearly, we also need to look forward in terms of the implications on employment as well, when and if the local plan extends beyond 2039 towards 2040, 2041 as well. So we are here all about looking for growth, looking for employment, looking for jobs, looking for homes, and looking at the future in terms of the growth of the region and trying to do that in an aspirational and visionary sense, trying to provide for the people that are here and obviously in years to come. So with that, I would just like to say, I think that, again, just in that response, the council missed employment. Thank you, sir.
Okay, thank you. I think it gives enough time, enough information just to consider that point at this stage. We'll obviously review, we'll consider that further, basically the comments that were made in relation to the amendments that you suggested. So at this stage, I'm just going to move on to climate change. Just the response again to question 1.19. Can the council identify both the strategic aims and objectives and policies that ensure the plan secures development that contributes to the mitigation and adaptation to climate change? If they could, in the first instance.
Hi, yeah, was that regarding the level 2 SFRA? Was that the...
That's my next question.
Okay.
Yeah, I just wanted to, I mean, you can deal with it all at once if you wish, but yeah, the next question is obviously how were the mitigation measures identified in the recently published level 2 SFRA strategic flood risk assessment be taken into account responding to the effects of climate change? So there's obviously, it's a wider remit, so I'm asking for initially, and then probably you can zone in if you can on the issue of the level 2 SFRI, please, in terms of climate change.
Yes, thank you. So the written statement, the council responded to these question 1.19, setting out the response to climate change through the policies and the plan and the overall spatial strategy of concentrating growth within the urban area would have positive impacts on the effects of climate change. As part of the level 2 SFRA, that's identified planned flood risk management schemes within Sheffield, which will have a further positive effect on mitigation of existing sites and proposed sites, either through the plan or through windfall development. The level 2 SFRA also identifies site-specific mitigations for site allocations, which ensure that developments remain safe for their lifetime and not increase flooding elsewhere. And where mitigation's not been considered feasible, then we've suggested modifications
which would either result in the deallocation of the site or reduction in the developable area of the sites.
Okay, thank you very much. Just moving on then to the issue of basically equality. Basically, obviously, the impact of the local plan on people, that are the relevant protected characteristics are defined in section 149 of the Equality Act. Have any negative impacts been identified, and how will they be addressed?
Yes, so this is essentially set out in Exam 21, which is the Equality Impact Assessment. It sets out how the equality implications of the plan have been considered and identifies any negative effects. Our conclusion is that the draft plan will have an overall positive effect, will support the duty to enhance equality of opportunity, will not result in discrimination of any equality impact group. We do recognise there could be some negative impacts as a result of aiming to achieve the housing growth and economic growth required by the city whilst trying to enable choice and opportunity. But achieving the level of growth set out in the draft plan potentially has massive equality benefits for a large number of people through the provision of more and better quality homes and the provision of new jobs. When the cooperative executive advised on the overall spatial strategy in February 2022, at that point it was emphasised that there are some potentially negative equality impacts of pursuing a growth strategy that does not allow any release of greenfield sites in the Greenbelt. Limiting development to the existing urban areas with no outward expansion means that the level of growth is restricted in some areas. In particular, this is likely to reduce the overall number of affordable homes, and we'll talk about this later in the hearings that can be delivered, because it is generally more viable to provide affordable housing on greenfield sites. However, the advice by the cooperative executive reflected the priority that the council is giving to the climate and biodiversity emergencies, the need to promote more sustainable travel, protect ecologically valuable areas, and so the strategy that we've set out, we feel, is the best way of delivering that overall sustainable development package for the city. So the regeneration of the central area is key to the plan in adapting to climate change through sustainable travel patterns and reducing carbon emissions. I think there was a feeling that we can't go on always just expanding urban areas and growing cities without considering how we can maximise and make more efficient use of land within the urban areas, which of course is what the government is encouraging us to do, and that's the strategy that we're promoting in the plan. So the equality impact assessment on page 5 draws attention to a number of policies which are expected to have positive impacts. Probably don't need to go through all those in detail. There's a long list of those setting out the benefits that certain policies, particularly in part 2 of the plan, have in terms of people with protected characteristics. Thank you.
Okay, thanks very much. Mr. Bolton, you still got some comments?
Yes. Mr. Vincent obviously has a much longer memory of me when he says we can't go on expanding the city again and again. My memory, I think, was the last development plan to make any allocations, of which it made about 2, was the 1998 UDP. I've got people working for me that are younger than that plan. The only real change that was made was the settlements to the south, which were released from the Greenbelt, and that was some decades ago. And the constant refrain about having a sustainable plan and the climate emergency, I simply can't see how we can address climate change and climate emergency simply by denying people homes, which is what this plan is doing, and doing it at quite a substantial level, 1,000 a year. That's what it's missing. Those people I mean, the council described them as footloose, as though they don't matter. They do matter. And of course, if footloose populations aren't necessarily the ones that are going to be excluded, it can actually be the more vulnerable in the city that are excluded. Because those who are able to move quite often have access to better finances, etc. So this constant refrain, I think, is wrong. In terms of flood risk, we deal with quite a lot of urban regeneration sites, and quite a few we have to have the exceptions test passed. We have to do sequential testing and then exception testing in order to get those permissions granted. So they are putting people in areas of risk. So I think there's this general refrain that if we say that it's sustainable, and if we say it's to address climate emergency, it gets us away from doing our job, I think is incorrect. And you need to look at what planning is meant to do, which is it's meant to balance all these things. And it can do that here. It's just that the council have decided not to do it, and are using that, if you like, as a green cloak for what I would say is a poor plan.
Okay, thank you, Mr. Bolton. Just moving on just to the final sort of response of the councils, just in relation to their statement, which highlights several inconsistencies and ambiguities in the definitions within the supporting text and the glossary. Obviously, there's a number of main modifications that are listed, I think, in their statement. I guess it's just obviously whether they think they're justified in terms of the actual the approach that's been taken. So just get a response from the council on those things.
Yeah, it's probably worth saying that in deciding whether to include definitions within the plan's supporting text or the glossary, the convention we've tried to use has been to include definitions in the glossary where they're used more than once in the plan, in more than one policy. So where a term is used solely in relation to that policy, then the definition is included in the supporting text to the policy. Where definitions are already provided in the MPPF, the glossary uses the MPPF definition. And I think that's really just to be helpful to the reader and to the public to make the plan more effective in that sense. So we have identified several inconsistencies or ambiguities in definitions in the supporting text or in the glossary. We've therefore suggested a number of modifications in CD 31, which we think improve the clarity and effectiveness of the plan. So that's modification references CH22, GD11, RH96, LS31, GC15, GC16, GC6, GC19, SV41, RH101 and RH102. The definition sections of several policies direct the reader to the glossary, but we found that the relevant definition in the glossary is missing in a few cases. That's essentially an oversight. The council has therefore proposed a number of definite modifications to the glossary in CD 31 to include broad locations for growth, catalyst sites, mass transit corridors, priority locations. In order to reflect proposed modifications to certain policies, the Council has proposed modifications to the wording of some definitions in the supporting text, or has proposed some entirely new definitions. However, we haven't dealt with those, as these are not really concerned with internal consistency within the plan, so they're not covered within this matter, but we will obviously highlight those in statements on other matters where relevant. So, yeah, there are some other changes which arise from other modifications where we think a new definition or a change to the glossary would be appropriate, but it does depend on which modifications are recommended.
Okay, thank you. Yeah, I think obviously those I've reviewed those obviously in terms of gone through them. They seem to be generally consistent with national policy, etc. To make the plan effective. I think obviously, so I think if they're added to the schedule of proposed mods, that you include. I think the only other action at this stage on this section really was just in relation to that. The neighbourhood plan paragraph, 1.28. Otherwise, we'll consider the other matters further as we go through the plan over the next few months. So, thank you.
So the only question I had was in respect, what we had really was in respect to the 15-year period point, and you heard those sat to my left and right discussing a sort of draft form of wording in terms of that. Would it be of assistance for us to put something together at this stage in respect to that, or should we leave that for now and see how matters unfold over the coming sessions?
I was actually going to come back and just make a quick point before we finish this item. I think it's important to set out our position actually on the 15-year plan period issue at this point. And basically our position, the inspector's position at this stage, is that we can't make a decision yet, because we very much feel that we need to hold the housing need and requirement session, and we need to hold the housing supply session, and then consider all issues in the round, and obviously actually also the employment session. I must mention that. So once we've held all of those sessions, then we will take a view.
Okay, so thank you very much. Unless is there any other issues on matter 1 that need to be raised at this point? So any sort of procedural or other matters that need to be raised? If there isn't, I think what we're going to suggest is we just so we can just change around for the duty. Sorry, Mr. Rose, have you got a comment you wish to make?
Yeah, just one quick procedural question, just so I've got my notes correct. Is the tables ahead of matter 5? Did we hear a date earlier? What was the date they were coming out?
Yes, I think we said Monday, didn't we? Yeah. I think we said Monday or sooner if they're available.
If we could have it this week, because if it's Monday, it's very late before Tuesday, and obviously we're bringing colleagues up.
Yeah, we do understand that, which is why we said Monday at the latest, but we'll endeavour to get them done as quickly as we're able to.
Yeah, thank you, Mr. Rose. Yeah, obviously the earlier the better. So certainly it would be useful for all parties to see that. If we can, please, that'd be beneficial, much more beneficial. So we're just going to have a short break before moving on to matter 2 on the duty to cooperate, just so we can swap round. I think National Highways are going to come in on this session. So I'm just going to basically, obviously, thank you for your contributions on matter 1. If we just have a break for, say, 15 minutes till 2:50, and then people can leave or move around as they wish, and then we'll reconvene at 2:50. Thank you very much. Is everyone back from the council that needs to be here? Okay, thanks very much. So I think it's just National Highways that are the main sort of new attendees today. So if you could just introduce yourself, if you could, please, that would be helpful, please. Thank you. Yeah, it's the big button at the bottom first. And then,
there we are.
Yeah. Okay.
Right. Thank you, sir. Thank you. Good afternoon, ma'am. I'm Simon Jones from National Highways, here to represent today. We have colleagues also, Mr. Edwards and Mrs. Pennells, who sits behind me from the joint venture Sistra Jacobs. Just move that away slightly.
Sorry, could you just repeat your name? Sorry, I didn't quite catch it.
Simon Jones from National Highways.
Okay, yeah. Okay.
And to my left is Mr. Edwards, and immediately behind Miss Pennells.
Okay, thank you. So just if you want to obviously turn the mics off when you're not talking, it's just obviously because it's on live stream, it's obviously people need to hear what people are saying. And obviously the mics are the main way people are going to be able to hear us. If you want to talk, the only additional thing is just to turn your nameplate on its end. I'm sure you're used to the procedure. So other than that, just make sure mobile phones are silenced or turned off. So I've just got a few questions on matter 2 arising from the statements and the evidence. Really, an issue just to do with engagement. So, in terms of timing of when did the engagement on duty to cooperate commence, and what process and groupings have been used by Sheffield to engage with other local planning authorities and other relevant organisations at each stage of the plan preparation. If you could just respond to that first. Thank you.
Yes, thank you. So, yes, ongoing engagement takes place in the form of both meetings online and face-to-face and written correspondence. That's been documented through the two duty to cooperate position statements, DC01 and DC04, that were issued in 2022 and 23 respectively. In terms of the engagements with related local planning authorities, that's very long-standing. Particularly with reference to the Sheffield City region, which has been, obviously that's now been replaced by the South Yorkshire Mayoral Combined Authority, but that's been a long-standing relationship. And in fact, previously through the Yorkshire and Humber Regional Assembly, there's a real culture of ongoing communication engagement with our neighbouring authorities. For the purposes of developing the Sheffield Plan, engagements documented from early 2020 prior to consultation on Regulation 18 issues and options. The reference point there is the Sheffield Plan Duty to Cooperate Statement 2020, which is DC03. Thank you for pointing that out when we were offering to submit it as an additional examination document. Hadn't realised we'd already got it on there. I think that's really important because that clearly sets out what the framework for engaging with those local authorities is and how we understand the duty to cooperate as set out in the legislation. I think typically discussion with local planning authorities has taken place on a one-to-one basis, although clearly there has been engagement as a sub-region, particularly through head of planning meetings, which continues, and as an output of that through the South Yorkshire Mayoral Combined Authority and South Yorkshire sub-region statements of common ground. They demonstrate the elements of the outputs of this continued work across a whole range of strategic, cross-boundary, thematic areas. A series of meetings have been held several times a year with key local planning authorities, and that's been supported in between times with additional email and written correspondence as appropriate. Again, that's listed primarily in those two duty to cooperate statements. I understand that you had asked for the content of those communications, which we have now provided to you with advice from our, I can't think what the right terminology is, a GDPR team around. We've provided you with the full documentation, unredacted, so that you can clearly see trains of communication. You'll have received a note with that around the procedures that would be required if we were to provide that in public. The outcomes of this long-standing continuous engagement is most clearly documented in the Local Planning Authority's Statement of Common Ground, which is Exam 37. And the signatories to that are heads of planning or relevant key members, dependent on individual local planning authorities' schemes of delegation. It's particularly important to notice that agreement has been reached to produce a joint South Yorkshire Waste and Minerals local plan by the heads of planning. Local authorities have agreed to that joint plan to be produced, and that's set out in the Statement of Common Ground across the sub-region, which is exam document 4C, and also noted in the Local Planning Authority's Statement of Common Ground, which is exam 37. Do you want me to slow down?
Just a question, was that minerals and waste or just waste?
I think I said that by accident. Waste.
It's just waste.
It was
Yeah,
waste.
okay.
And it doesn't even say minerals and waste on my notes. Sorry, it came out wrong. Yeah, that's a waste local plan. It's worth noting that the joint, the sub-regional Statement of Common Ground was submitted as document DC05. At that point, I think some people have pointed out that wasn't fully signed at that stage. The signed version is now available as exam document 4C, and that sets out the local plans are adopted or being produced across the city region. Plans are obviously at a different stage of preparation whilst we've been working on our local plan, but that draws together thematic elements across the whole of the sub-region. Just as a final point, other relevant organisations and prescribed bodies have clearly been engaged throughout as appropriate. That's also documented through the duty to cooperate position statements. For example, there's evidence of engagement throughout the level 1 and level 2 SFRAs with the Environment Agency. We've already heard today from correspondence from Natural England and also from the Peak Park on certain themes. And across from you, we have National Highways, who are also representing a key partner that we've engaged with throughout the plan-making process.
Actually, if basically just bring you in there just to get your views on the engagement through the duty to cooperate process at each stage, basically how basically that where's that been effective and constructive in terms of how you've been able to deal with issues within the plan that are relevant to your area.
Certainly, thank you, sir. Yes, we've worked for a number of years with the council to ascertain the impact of the local plan development as proposed on the strategic road network. We've jointly undertaken over that time period strategic modelling work across the network, predominantly the M1, the A616, A629, A628. Having reviewed the local plan and the impact that it has on the network, we've done so against the current adopted DFT policy, Circular 0122, which basically outlines the Secretary of State for Transport's requirements that those identified impacts on the network are managed down. Consideration is given to alternative solutions, consideration given to sustainable transport measures, and ultimately then the mitigation of any residual impact on the network. As you'll have seen, exam document 36, I believe, is the Statement of Common Ground between ourselves and the council. And this was submitted and signed April 2024, and that outlines the suitable and the proportionate approach that has been taken to the transport evidence base between ourselves. We are agreed with the council that the duty to cooperate has been met, and that we both remain committed to the ongoing work which will follow after the adoption of the local plan, and that will be necessary when looking at the safe and continued operation of the strategic road network.
Okay, thank you very much. Just in terms of National Highways, Mr Jones just touched on it there about ongoing engagement, about the commitment to ongoing engagement through the delivery of the local plan. Could you just give what format that will take just going forward, so we've got an idea basically how this will be undertaken?
Yes, thank you. I was just about to mention, but Mr Jones got there in front of me. We've been discussing with National Highways the possibility of us establishing review points for that work. I think in terms of other stakeholders, whether that's local planning authorities or other prescribed bodies, as I mentioned in my answer to the previous question, first of all, the Heads of Planning Group continues to meet bi-monthly, which is a really important forum for discussion and also work programmes around strategic cross-boundary issues. At an officer level, there's continued engagement on those cross-boundary matters in both respect of our own Sheffield Plan and plan reviews as they might transpire, but also in respect of other authorities' plans as they evolve through their own review processes. And that will continue to take the format of regular one-to-one meetings with relevant officers from each local planning authority. Furthermore, there's a commitment to review the sub-regional statement of common ground within 1 year of adoption. That's noted at paragraph 5.2 of exam document 4C. That provides the framework for ensuring continued dialogue across the wider area as plans are implemented. We've already discussed specific issues where engagement will continue in a targeted manner as set out in relevant statements of common ground. So, for example, with the Peak Park and the Natural England on the mitigation issues identified that we talked about earlier this afternoon. And we do envisage that once we got to the stage of plan review, we would then begin to focus again with local planning authorities and prescribed bodies regarding the scope of that review.
Okay, you mentioned the information you provided in terms of the more detailed information about that sort of set out in your submitted duty to cooperate position statements. I think obviously you produce it in a redacted format. I think if, as you've suggested, if you could submit that in a redacted format, so that can be added to the examination sort of website, it would be extremely useful to have the background detail about how that sort of the letters, emails, any meeting notes, how that interaction has taken place, and then responses, just so we have that information available.
Okay, I think obviously we've provided that to you because we needed to be able to see the flow of communication. I'm pleased that you've hopefully found that useful. I just would make you aware that we're more than happy to carry out that request. It will take some time because, as you're aware, it's I think around 300 pages long of dense email text and other communication. So there's a fair amount of work to do there. So I appreciate if you can give us the time to do that properly.
That's fine. I appreciate it will take quite a bit of time, but if unfortunately there's a bit of information, I think we do need to. It has been raised, so I think we just need to sort of try and provide that. Yeah, if we just put it as an action point, and then obviously if you could provide that, as soon as practicable, really. Is there any other engagement issues on this particular matter due to cooperate? Otherwise, I'll just move on. Yeah.
So not in terms of highways, but in terms of the general duty to cooperate in the housing matter, if I can comment on that.
That's fine.
Is that okay now?
Yes.
Okay.
Yes, please.
I suppose the point is, firstly, is housing a strategic matter in Sheffield? Yes, it is. Is the issue of unmet need a strategic matter that needs to be discussed between local authorities? Yes, it is. Should that matter have been discussed and resolved prior to submission? I think that should have happened as well. And what we can see from the now signed statement of common ground, which is after the date of submission, is that there is an undertaking that local authorities will meet their needs where it is consistent with national policy, and that for Sheffield means they do not meet their needs. And there is a statement in the sentence following that no other local authority will take on board that unmet need. So that's quite clear where we are. And there's a good reason for that. If you look at the table 1 in the statement of common ground, it sets out the need as calculated in the different local plans. and the case being made by Sheffield, which I think is...
Sorry, could you just table one? Where,
so,
which
statement? Statement of common ground.
Which statement? Yeah, is it the is it exam document 37? Is it the one with the local authorities?
37, yes. And it's...
Excuse me, I think is it 4C? Is it the South Yorkshire one you're referring to?
Yes, it's South Yorkshire one.
Well, signed one is.
Unfortunately, yes, I've got it open. Got it open on my laptop, so it doesn't actually give me the CD number at the top, which is a bit unfortunate.
The signed South Yorkshire Statement of Common Ground is
Yes.
exam 4C.
Yeah, that's the one. And it's table 1, and it's on page... PDF page 43, I think it is. Oh, 41. No, sorry, 42. And there you see a range of local authorities, and what's being put to you is the 2022 annual local housing need figure as calculated by the standard method, which of course is a minimum requirement, remember. It's not the final need figure. And what you see is a local plan target next to it, which is different. And the reason it's different up here, and we've sat in most of these local plan examinations, is that there's a higher need figure because of the economic circumstances and objectives of those local authorities. So that higher figure has been set and agreed by inspectors at local plan examinations as the housing requirement for those areas in order to meet the housing needs of those areas, taking into account the economic the economic growth and strategies for those areas. Most recent one that both me and Mr. Rose sat in was the Doncaster one, where the local plan target, the actual need figure is 920. That's very much set to accommodate Doncaster's economic aspirations and the housing needed to support that. So the suggestion in the Council's Matter 2 document to you in paragraph 3.3 that this table shows that there's flexibility. In other words, don't worry about the missing 1,000 a year because somehow that's going to be picked up or accommodated within these other plans. It's simply untrue. And it also doesn't really accord with what's being said in the Statement of Common Ground, because there it says the other authorities aren't going to meet any need. So you have a situation here where I think the duty to cooperate should have been engaged, and there should have been a serious conversation between Sheffield City Council and the surrounding areas that need should be met somewhere. I can understand why not, because as we've already discussed, many of the local authorities listed, in fact all of them, have undergone greenbelt reviews and released greenbelt sites, not strategic greenbelt sites, but reasonable sized greenbelt sites in sustainable locations to meet their economic needs. So it's not surprising that those local authorities are unwilling to do more to meet Sheffield's needs when Sheffield are unwilling to, if you like, they make those decisions themselves. So that might be a bit political, but it just happens to be true. So the bottom line is I don't think the duty to cooperate has been fulfilled in this particular case.
Councillor, do you want to just respond on that, particularly just the point? Obviously, thank you.
Yeah, sorry, let me just... is that on? Right, sorry, I can't see the red line. Some of the matters that have been raised obviously are substantive issues which will be covered in future sessions. I mean, this session is dealing with the legal obligation in terms of the duty to cooperate. And the Council's position is it's clear from both the position statements and also the statements of common ground that are in front of the examination that there has been compliance with that duty. Whether or not interested parties agree with the outcome of that process and whether or not they think the plan is sound, it is another matter, and that's for the substantive session. So I just set that out because we're not going to respond in detail to every point now that's just been made. In terms of the statement of common ground that you've just been referred to, I mean, obviously, as I set out at the beginning, it's important to have regard to the entirety of it, which we know you will. But you can see at paragraph 4.2.1 on page 16 that what's actually said there is that all local planning authorities in the region are planning to ensure that their own housing needs are met within their local authority boundaries, comma, where this is consistent with national policy. So that's really important there, where this is consistent with national policy. And then in terms of what the other authorities understood Sheffield was doing, or was proposing to do, we can see at 4.2.3 recognition that the draft Sheffield local plan sets a housing target of 2040 homes per year, which is 978 below LHN for Sheffield. So there is it's not correct to say that this is somehow indicating that Sheffield is going to meet its full LHN and that therefore there's a misunderstanding between the other authorities as to what's being discussed and proposed. I think that's clearly set out, and that's also clearly set out at the table that's been referred to at page 43. But of course it is open to the authorities when they're discussing these matters as part of sensible engagement to also have a think about what the impacts of some of this are going to be. And so we have table 1 regional housing needs, and what that does is it puts the figures in terms of both LHN and in terms of local plan figures in the regional context, and it shows the extent to which across the region LHN is being met in circumstances where some plans are providing for more and some for less. So that's clearly the purpose of that table. But I mean, again, there might be a disagreement in terms of the relevance of that, but the key point is that the Statement of Common Ground makes it clear that there has been discussion in respect of these matters, that the local authorities, are aware of the issues in Sheffield, and that they are not proposing to meet any of Sheffield's needs. And that's also documented in further correspondence and letters that are on the examination website. So the Council's position is that it's met the duty to cooperate and the obligations that fall upon it. And it's not a duty to agree, but actually there was agreement between you here that they weren't meeting your needs.
Yeah. Mr. Bolton, do you still you want to respond? Nameplates up.
Yes. Firstly, it's good that we are in the same place, that the needs of Sheffield, it's been agreed that the needs of Sheffield aren't being met by the other local authorities. I think that's what's just been said. You've just been told that LHN, local housing needs, is being met in table 1, and you were referred to, if you like, that first column. That is incorrect, because standard method gives you the minimum. It doesn't give you the final need figure, because the final need figure can include the economic uplift. I think you understand that, and that's all I want to make. Cheers. Thank you.
Just to be absolutely clear on that point, what I actually said was that the table represents LHN, i.e. calculated in accordance with the standard methodology, and then next to it puts that in the context of local plan targets, i.e. local plan requirements or proposed requirements. I fully understand how the standard method works in terms of, uplifts can be agreed over and above that through the local plan context, but the table is setting out 2022 annual LHN figure, column A, and local plan target B, and then the difference B minus A, and then local plan status.
My point, sir, and I'm sure you've got it, is attending those examinations, it is very clear that the targets in the requirements set by the local plan are the targets required to meet the local need figure, because the local need figure can be higher than the minimum figure.
Yeah, I understand.
You
Thank
understand
you very much.
that? Yes,
Thank you. Thank you for your point, Mr. Bolton. So the only other point really I got is in the area of disagreement, really, in relation to logistics, which obviously was picked up under question 2.5. And obviously, in terms of the way you've set out the statement of common ground with the local authorities, you know, it's very clear, obviously, the areas where you agreed and disagreed, and obviously one of them is logistics. We obviously talked about the Peak District National Park earlier, which has been dealt with, obviously, through that discussion on habitats regs assessment. But just obviously, in terms of this issue, do the council consider they're constructively and actively engaged on an ongoing basis with the relevant authorities on strategic matters in relation to this particular issue and large-scale logistics? And are there any significant implications for other authorities despite not being able to reach agreement in relation to the approach to large-scale logistic developments with with other local authorities?
Yes, we've touched on already today the sort of employment issues around logistics and the need for that to be picked up in relation to, in terms of the IIA addendum, and that'll be covered, and we'll also be covering that more fully under Matter 5. The Statement of Common Ground with the Local Planning Authorities, Exam 37, clearly sets out the areas of disagreement, which are grounded in the approaches of those local planning authorities to delivering logistics development to meet their own need. We have had, extensive discussions with the other local authorities, particularly Bassett Law, based on the findings of the Sheffield Logistics Study. It is our view that there is sufficient land within the wider strategic economic market area to meet the need for logistics uses. And some of the other local authorities, primarily Bassett Law, dispute this. I think I think it's a matter that needs to be discussed needs to be discussed under Matter 5. But I think I'd just draw your attention now to the Sheffield Logistics Study, paragraph 7.5, and our case really is based on this assessment here, which says that looking across an even wider area that extends to the south and east of Bassett Law, as well as Chesterfield, North East Derbyshire and Bolsover, the levels of supply increased substantially, primarily due to Bassett Law's significant allocations. Even without a contribution from Sheffield, the supply goes above the 87 upper end of the needs range model. This could be a factor in considering a level of provision that is less than the full model needs for Sheffield, given the nature of occupiers for large B8 units tends to have a much wider area of search. So I think this will probably need to be discussed under Matter 5. I think we've taken it as far as we can in terms of the discussions with Bassett Law. I don't know whether, Paul, whether you wanted to comment on any of this.
Just, if it's helpful, sir, just to point you towards Bassett Law's local plan, which was adopted in May 2024, which in of itself, drawing upon another piece of evidence, actually concluded the same property market area that Mr. Vincent was just referencing there. So whilst Bassett Law has lodged their point of objection, actually the consideration of the logistics matter has been considered at the same property market area for both their study and our study. We can get, as Mr. Vincent says, we can get into the details maybe more on Matter 5, but I did wonder whether it might be useful to actually have the inspector's report for Bassett Law's local plan, given it's quite contemporary and does sort of grapple with this logistics issue as well, given it's Bassett Law's objection that we're obviously contemplating. Again, I'll take your lead on that, sir.
Thank you. Mr. Rose, do you want to raise some comments, or is there any other comments from anybody else?
Waiting till the appropriate time to come in, sir. Thank you, sir. Yeah, obviously we're straying into matters for matter 5 at the moment, sir. So, but clearly, I think in response to your question, obviously there's a duty to cooperate. We've obviously heard the council have spoken to their adjacent authorities. Clearly, in terms of employment and logistics, there is an objection from Bassett Law. We've all seen that. They clearly disagree with the council's approach, clearly disagree that the council aren't meeting their needs, the identified need within the, the logistics study and also the employment land review. And clearly the council are seeking to divert and deflect that argument out into the wider region, stating that there are other sites around in terms of the FEMA, the property market area, whatever you want to call it, but clearly employment has a wide sphere. You've been directed towards the Iceni study and paragraph 7.5. Clearly, I will direct you towards our evidence in terms of the Savills evidence that we've appended to our hearing statements. That clearly looks at the FEMA and the wider property market area and has analysed and assessed the sites that are available. You've been directed towards Bassett Law. I was also at the Bassett Law examination in public as well. And the site there, which is at Apley Head, which is a very large site, was clearly allocated and defined on a very focused area along the A1. In terms of that area, clearly we'll come on to that in terms of matter 5, and was very much around a focused need along the A1 corridor between Doncaster and Nottingham, D2N2. So we've obviously appended to our hearing statements a report by Model Logic, which has clearly examined a lot of the junctions around the region and identified why junction 35 is one of the best junctions in the region and why it should have strategic employment identified and allocated on it, not just for the wider region, but also for Sheffield to meet their needs. And this is all about Sheffield meeting their own needs. That's why Bassett Law have objected. That's also why Rotherham put in an objection as well. Earlier on in the plan, around the fact the council aren't meeting their needs and the wider impact of that on the region. So in terms of the duty to cooperate and obviously outstanding matters, you can clearly see that there's a disagreement because of the council's strategy and the council's approach. There are sites available, they can meet their needs, they can do that, they can then not impact on the wider region and they can make their way on that. So in our hearing statements, we directed you towards earlier statements of common ground or duty to cooperate or whatever you want to call it, highlighting that the council say that they can make provision. The council view is that the provision of land in the Sheffield Plan will enable the meaningful contribution towards meeting the demand for logistics uses. The council aren't making any meaningful allocations or any meaningful contributions towards logistics, particularly in the modern requirements of INL. Obviously, we'll come back to that on matter 5, but given you've been directed towards our senior reports and Bassett Law, I thought it was pertinent to actually come in at this point, sir. But clearly, we've got a lot to discuss, I think, a lot to go through, so that we can come to the right solution for Sheffield and the right solution for the Sheffield City region, so that we can deliver jobs and growth. Thank you, sir.
Okay, thank you. Yeah, it probably would be useful for the Bassett Law plan to the report, inspector's report, just obviously with the reference that we made. Do you want to make some further comments? Your nameplate is up, so...
If that's okay, sir,
yeah.
and it goes to the heart of what you just said, really. I mean, I don't want to have Bassett Law's examination during our own examination, but, you know, this point about the Apley Head site, I think, will recur on the 2nd of July on matter 5. But just to sort of put it into the back of your mind, this point that it was a specific site for a specific reason, the actual allocation of that site within Bassett Law's plan, I won't read it all out, but it does say that the proposal for the Apley Head junction will be developed for sub-regional and or regional large-scale logistics. So I think it's pretty clear that the site is intending to serve a wider market area than just what Mr. Rose said earlier. And of course, it's our evidence that it does contribute towards quite a considerable amount of land supply within that wider property market area. So just, I think, yeah, if it's helpful, sir, we'll get those on the list of documents, I think.
Okay, I don't want to get into a huge debate about logistics. I'm trying to focus on the due to cooperate issue today. Obviously, matter 5, we will go there. Obviously, in terms of looking at this particular issue, in terms of how logistics are met beyond the actual city area. But if that's unless there's anything else you want to raise in particular reference to due to cooperate, Mr. Rose.
No, sorry, it's just a response because obviously it's just you've got to look at the evidence rather than just look specifically at what that states, but clearly supporting the Bassett Law Council's plan was a specific study on the A1 and a specific study on that corridor, sir. And that was the justification for it because it is so large and so much bigger, but it was all about meeting a specific need, sir. And I think that is why Bassett Law have objected, because it's to meet the needs of Bassett Law and that side of the A1.
Okay, Mr. Vincent, do you want to come back in here?
Yeah, it's just sorry, I'm sort of dipping between two mics. It's just a very, very quick point because we're not going to answer all those points now because we think there are a number of substantive points again that come out in future sessions, and this session is about the duty to cooperate. And so we just as well, we've heard that there's an objection, which there is. Obviously, it's a duty to cooperate; it's not a duty to agree. But in terms of matters where there have been agreement reflecting the engagement that's occurred between the authorities in terms of this, we just draw your attention to the entirety of section 4.3 of the Statement of Common Ground, which sets out numerous matters that the authorities have looked at together and have agreed on, and that's over several pages there. So that's just for context, really.
Okay, I haven't actually there's no further questions really on due to cooperate. That covers everything I need to at this stage. Is there any other matters that anybody wishes to raise on matter 2 in relation to due to cooperate? Okay, if that's the case, just obviously thank you for your contributions. Obviously finishing a bit early, so that's beneficial. Long session, I think, tomorrow on housing. So for those attending, it's due to commence obviously at 9 a.m. tomorrow here, Howden House. So I'll obviously see you there. Thank you. Bye-bye.